Hello, my name is Jennifer Huddleston, and I'm a Senior Fellow in Technology Policy here at the Cato Institute. I'd like to welcome you all who are here in Cato's auditorium in Washington, D.C., as well as all of you tuning in online to today's conference on Section 230 at 30, the past, present, and future of the 26 words that created the Internet. Let's go back to 1996 briefly. While I'm not going to ask any of you to do the Macarena, or to reflect on the 96 Olympics and the U.S. gymnastics team's gold medal win, known as the Magnificent Seven, or to play your Nintendo 64 games, I am going to ask us to spend today reflecting on the 26 words that created the Internet. Almost from its start, there's been a lot of debate about what those 26 words actually meant, as you'll hear on our first panel about the past. And certainly today, there's been a lot of controversy about what Section 230 means for the expansion of online speech, for platforms of different sizes, including both large and small platforms, and for issues like youth online safety. So our second panel today will discuss what those present challenges look like and what they mean for the current debates over Section 230, both in legislation and in litigation. And then finally, one of the key elements about Section 230 was how it was able to look forward, how it was adaptive and creative. And needless to say, as we look forward to the new AI era, this is raising new questions. Additionally, we're seeing platforms try different content moderation strategies that also bring with them questions around how Section 230 may play out and interact. Additionally, I'm excited that just before our lunch break, we'll have a brief online fireside chat with Senator Ron Wyden, one of the two authors of this law, and a unique opportunity to really gain insights from one of the law's authors on what the law means, how he's thinking about these current challenges, and what he foresees in the law's future. With that, I'm excited to thank all of our panelists today, and particularly to start with our first panel. So at this point, I'll welcome to the stage my colleague, Tommy Berry, who is the director of the Robert A. Levy Center for Constitutional Studies here at the Cato Institute.
Well, thanks so much, and thank you all for coming to Cato this morning for a fantastic program we've got today on the 30th anniversary of Section 230. As Jennifer said, we've kind of put this in chronological order, past, present, and future. So we get past coming first up. And to start, I'd like to remind the audience online that as we're going, they can submit their questions in several ways. They can submit it via the event's webpage in the little box under the screen, on our Facebook page, on YouTube, or on X. And now we'll get to questions with about 15-20 minutes to go in the panel. So I'll start off by introducing our three panelists, and then we'll get right into a series of questions, kind of walking through the origins, the reasons for, the creation of, and the early interpretations of Section 230. So to my immediate right, Jessica Malugin is director of the Center for Technology and Innovation at the Competitive Enterprise Institute, where her research focuses on technology issues, including antitrust, online privacy, artificial intelligence, telecommunications, social media content, and net neutrality regulation. She's an Innovators Network Antitrust and Competition Policy Fellow, and she graduated magna cum laude from Claremont McKenna College with a degree in government and art history. Next to her, Samir Jain is the Vice President of Policy at the Center for Democracy and Technology, where he leads CDT's policy advocacy, strategy, and policy teams. His previous positions are many, and they include serving as Senior Director for Cybersecurity Policy at the White House National Security Council. He serves on advisory boards for American University's Tech Law and Security Program and the Future of Privacy Forum, among others, and he holds a BS from Stanford University and a JD from Harvard Law School. And finally, at the far end, Professor Eric Goldman is an Associate Dean of Research and Professor of Law at Santa Clara University School of Law, where he co-directs the High Tech Law Institute and supervises the Privacy Law Certificate. His research and teaching focuses on internet, IP, and advertising law topics, and he blogs on these topics at the Technology and Marketing Law blog. He received a BA summa cum laude in Economics and Business, a JD, and an MBA, all from UCLA. So let's jump right into it. And again, following the structure of the program overall today, we're going to try to go in chronological order. And all of my questions are really going to be jump balls for the whole panelists. I'm not going to direct any one specific question to any one, because I think they all bring important backgrounds and different expertise on these issues. So let's start in the pre-internet days, because to really understand the legal landscape as the internet was developed, you have to understand what did courts have as precedents from similar or analogous issues that developed in the dead tree era. So before the internet developed, what did the law say about potential liability for distributors or sellers of written material? The Supreme Court had decided some cases like Farmers Educational and Cooperative Union of America versus WDAY, or Smith versus California. You can discuss those or others, or just in general, what was the law in the pre-internet era like?
I'm going to make the girl go first? Okay. Thank you. That's very chivalrous of everyone. So I think for the purposes of our discussion on Section 230, it's helpful to understand that before Section 230 and before the question of how do we deal with these issues in the online context, you kind of could, this is a bit of a simplification, but it's accurate and I think it's helpful in thinking these things through. You could be a distributor, and that might be a bookstore or a newsstand, and in that case you had very limited control over the editorial content of the products you were distributing, so accordingly you had limited liability for any illegal content in there. Or you could be a publisher, like a newspaper, and you would have pretty tight control over that content, right? So accordingly, you would have much more legal liability in that situation. So, I think that was the framework that courts were trying to jam these new message boards, which now we would say are websites and social media and lots of things, but at the time were message boards. They were kind of trying to figure out, well, which one is that? Are they distributors or are they publishers? And what Section 230 eventually said was, well, kind of neither framework really works very well and creates the correct incentives. So I think going into these cases, you see, the W-Day case was a radio station that, under the Telecommunications Act from the 30s, had to give equal time to a Senate candidate. So they were basically forced to put this person on the air. And that left them, obviously, with not very much editorial control to remove or stop someone as he started accusing people of, I think, being a communist farmers community. So, the courts kind of said, well, gosh, if we're going to force them to host this, we also can't then hold them liable when sometimes it goes sideways. Okay, so that, you kind of can get your head around that. And then the Smith case was about, why has California always got the dirty stuff? I'm a Californian, so I can say that. But it was a bookstore, and there was, of course, a dirty book in it. And out there, the court said, well, the bookstore is just a distributor. This owner of this bookstore didn't know that there was an obscene book in there. And if we make distributors liable for things that they didn't even know about, they're only going to sell like the books that they take home and read that night. And overall, that's not good for the flourishing of free speech and expression. So those are the kind of cases and situations courts had been thinking of, but of course, Section 30, the circumstances were very different.
Mm-hmm. Other thoughts?
I would just add, as an example, the New York Times versus Sullivan case, where it was clear that the New York Times was a publisher of the advertising at issue, but because they couldn't easily verify the facts that were in the article, in the advertisement, the Supreme Court essentially created the actual malice standard to give some breathing room for content that wasn't really theirs. And we often forget that that was a case involving third-party content. It was just a sign that the starting premise in the day was, if you publish third-party content, you are legally responsible for it as equally as if it were your own.
Yeah, very important point, very important context there. So we start to get the development of the internet, the late 80s, early 90s. It looks a lot different from what it looks like today. We get message boards are one of the first, what you might call platforms or places where you have freewheeling speech. People are posting things, sometimes things that might or might not be defamatory, or some people think they are. So when we had these very first conflicts about speech online in the early 90s, what did courts say in cases like Cubby versus CompuServe and Stratton Oak Larchmont versus Prodigy, how did courts try to take the analogy or take these precedents from the pre-internet era and figure out how they apply to the internet?
Sure. So Cubby versus CompuServe was a case involving a message board in which CompuServe, which was the online entity, didn't do any kind of moderation, didn't review any of the content. It was really third-party content. And the court really analogized it essentially to a distributor, a bookstore, and said that the framework from Smith versus California that Jessica talked about should apply here, that CompuServe was essentially a distributor of third-party content, and since it had no knowledge of what that third-party content was, in the same way that the Supreme Court in Smith versus California said, in the absence of some kind of knowledge, the bookstore can't be liable. Likewise here, CompuServe is serving the analogous role. It didn't know anything about the content, and therefore it shouldn't be liable. Now, but by contrast, around soon thereafter, there was a different case, Prodigy, in which Prodigy, by contrast to CompuServe, held itself out as a family-friendly service and said, we actually do moderate. We do make sure that the content isn't going to be offensive. And the court there said, well, because you're undertaking that moderation responsibility and you're not simply serving as a pass-through for content, you can be potentially liable for that third-party content if your moderation fails and you let something unlawful or tortious pass through. And that case really was, in some ways, the motivation for Section 230, because if you think about the incentives those two cases together set up, what they said together was, well, if you just blindly allow any third-party content, don't do anything to try to filter it, you're fine, you're not liable. But if you try to undertake some kind of filtering, if you try to make your service family-friendly or any other kind of moderation, trying to make it specific to a particular community, then all of a sudden you're potentially liable. And so what's the incentive then is not to engage in that kind of moderation or filtering. And for many people said, well, wait, we want these services to, for example, not allow obscenity or not allow, or to offer a service that doesn't have nude images that's family-friendly, okay for children. And we've created the opposite incentive. And that was eventually what really motivated, it was one of the key motivations for Section 230.
Yeah, I think the analogy is, and people have said this isn't mine, but it's, I think, really helpful, is that you have a doctor and a lawyer driving down the road in a car, and they see an accident, and the doctor's impulse is to stop and help them, and the lawyer goes, whoa, whoa, hold on, because if it goes wrong, we could both be in a lot of trouble, so they drive on. And I think that's what Christopher Hawkes and now Senator Wyden were concerned about, is they were creating this disincentive for kind of a good Samaritan moderating online. And also, if you think about not even good or bad content, whoever's idea of that is, but also just to make interests more narrow, even to say, I'm going to set this up and it's just going to be about this one particular interest. It also, Section 230 allows for lots of variations of what a site or a platform or a message board can be. And I think they wanted to sort of let those variances work themselves out in a way that people felt legally comfortable doing.
I thought that doctor lawyer joke was going to go in a totally different direction.
That's after the panel.
Sure where that was going.
Yeah, I got a different one for us
I
after
could add a new punchline. I would just add that at the time when the Cubby versus CompuServe case came out, it was viewed as a pro-online speech ruling. It was like, look, there's a safe harbor or a zone of activity that's protected from liability. But it was really actually quite narrow. At minimum, under the Cubby versus CompuServe case, a heckler's veto type notice would have removed content. So we kind of think like there were these two rulings. One was pro-defense, one was pro-plaintiff. And actually, I don't view the Cubby case as even really being that much pro-defense. The legal standards before Section 230 were pretty dire. Either you were guaranteed to be liable, or you were at minimum subject to a heckler's veto and going to be liable. So the liability was there either way.
I mean, so as fans of Section 230, we're all inclined to be very skeptical of the Prodigy decision and the reasoning in both of those cases, as you said. Maybe before we move on, what is the defense? I mean, courts had some rationale for saying it should make a difference whether you're moderating it or not. If you wanted to sort of play devil's advocate for the best argument for why courts were doing that, what was the reasoning for saying that moderation or paying attention to what's going on, it means you're at more legal risk?
I think in the Prodigy case, it was holding itself out as a family-friendly service. That was what it was telling people, come to us because we're family-friendly. And so I think the argument would be, well, if that's what you're going to advertise yourself as, and that's why customers are coming to you, then you have a responsibility to actually be a family-friendly service. So to the extent that you fail in your moderation and allow, nudity or some kinds of content that isn't family-friendly, then you've essentially deceived consumers, and you should be liable for that.
Mm-hmm.
Can I add to that point? I actually think of the Stratton-Oakmont case as a advertising law case, in a sense, right? It was really, they were advertising themselves as family-friendly. The court's like, okay, you promise it, you deliver it. What I find so interesting is that the proof that the site wasn't family-friendly was that there was an allegedly defamatory statement. So it wasn't the paradigmatic examples of things that we would have considered to be disqualifying as family-friendly. And yet that got lost in all this. The court's just like, you said you were family-friendly and some plaintiff is upset, now that means you've disqualified yourself.
Yeah, it did take a little different turn in the details. And I think very broadly, the best, in the light most favorable to the defendant or attackers of Section 230 is that there are harms out there that aren't being absorbed by these platforms, so they're not being incentivized to do as much as they would be otherwise, is the argument. I don't agree with that, but that is, I think, it starts there with these cases that, oh, there's some harm here. And people forget that it's not that there isn't any assignment of harm, it's on the person who was speaking. So I think that's an important point too.
Yeah, so we get these decisions, and you've already previewed it a bit. There's a reaction in Congress. What's the reaction in Congress? What are they worried about? And what was the role of Chris Cox and Ron Wyden? What did they want to accomplish when they saw these decisions, and what were they worried about?
They were lunch buddies in the members' dining room, which I think is particularly charming these days. And I think
because they're opposite parties.
Yes, they were opposite parties, but they ate lunch together. And they just started talking about this. I think they've both been following it in the news. And Chris Cox tells the story of, he had the Wall Street Journal getting on a plane from California, and he spent his flight sort of sketching out what the solution might be on his yellow legal pad, which is something old people like me still enjoy doing, yellow legal pads. And I think he reached out to Ron Wyden, who, they really had a lot of overlapping, I think, good impulses about free speech and the flourishing of this and innovation. I think they were very pro on that. And they also talked about how, because it was new enough, it wasn't, all these politicians weren't dug into their corners. So they, and then they would go on to make a very convincing argument. It was a bipartisan, overwhelmingly positive vote in the House for Section 230. But what they saw is, like, what are the consequences of this ruling in Prodigy? And it's that you're creating a huge disincentive to moderate. And what are you going to get at the end of that? You might get two different things, which is sort of the Wild West, which is probably going to be filled with a bunch of stuff that most people wouldn't even want to spend time viewing, that everything stays up. Or you would have the opposite of that, where so much gets taken down that it's sort of like Sesame Street level safety, so that nothing can be a legal liability. And I think that they wanted something more innovative, more productive, more useful, richer than that. And they came up with Section 230 to try to grow that idea.
And it was also passed or talked about in the context of a broader statute, right? There was what was called the Communications Decency Act, and this was a part of the Communications Decency Act. More broadly, the Communications Decency Act, as the name implies, essentially was trying to filter out, quote unquote, indecent content from the internet. And so it had some prohibitions on that ultimately the Supreme Court struck down as part of the ACLU versus Reno case. And so in some ways, Section 230 was an alternative or supplement to the Communications Decency Act by trying to incentivize Good Samaritan type of filtering. And as it turned out, it was the piece that ultimately survived, that didn't get struck down constitutionally, and is the piece that allowed for, filtering without fear of liability.
I think it's a really interesting legislative drafting approach, and for those of you who do that, this is actually a case study to review and think about, because it was written, as Jessica described, really to say we want a certain set of activities and how do we motivate that. And it was written in that sense rather broadly, not prescriptively, not, there's definitely technical jargon in it, but it wasn't written to necessarily root itself in the inherent practices of the time. It was to say, there's this function called editorial moderation that we want to have happen, and if you're doing that, you shouldn't be liable for whatever you choose to do. And having that kind of big, broad policy impulse and then seeing it translated into code, I think is really interesting from a legislative drafting standpoint. Most laws aren't drafted, I think, that cleverly, and I think that's why we're still discussing it 30 years later.
So I have the text of 230 here, the 26 words. Do any of you have it memorized and want to take a stab? Or do you want me to? I thought maybe you...
I have it memorized. I have it tattooed, but I can't tell you where. So, I mean, is this a memory test, though? Just to point out, there's actually more to Section 230 than 230C1. So, no provider or user of interactive computer service shall be treated as the publisher or speaker of another information content provider. I'm sorry, information provided by another information content provider. So, do you want me to show you?
Kinda.
That's at the after part.
I think we're getting to the indecency part of the segment.
Cato is not liable for anything that you may do on camera. So, what do those words mean? What were they intended to do? Why did they pick that language? Put it in plain English.
It does Section 230 does two things. It says, as we just heard, recited from memory very impressively, that the person who writes the post, the author of the post, is the person responsible for that post, not the host of that. And then it also says that if a host moderates some of what's up there, it doesn't become responsible for everything. So those are sort of the two. It also, I think, was federal preemption as well, which is, I think, an important point to talk about today, looking at the AI debate. One of the things that Section 230 said was like, and this is what we're doing. Like, this is interstate commerce, and this is us, and this is what we've said. So that one gets left off. But the two main things are saying, the speaker is the one responsible, not the host, and if the host wants to moderate their platform as they see fit, that doesn't trigger publisher liability.
And preemption being a doctrine saying that a federal law can supersede a state law if they conflict with each other. So a state law could not say, no, Section 230 doesn't apply in our state. This creates the rule nationwide.
Those were the constitutional days, my friend.
So, I mean, the way that courts have ended up construing that provision of Section 230 is essentially that there are three requirements, right? You have to be a provider or user of an interactive computer service, which itself is defined in the statute quite broadly. Second, that the content that's at issue has to be provided by another information content provider, meaning it has to be a third-party content. Paradigmatically, that's the user posted it, but it can be other contexts, as we'll talk about in some of the cases. It wasn't a user necessarily, but some other content provider, not the interactive computer service itself. And third, that the cause of action, or what it is that we're talking about that's trying to hold you liable, treats you as a publisher. Again, the paradigm case might be defamation, where being a publisher is actually an element of the cause of action. But so the courts later construed treating as a publisher basically meant that if it was trying to impose upon you any kind of duty or obligation that publishers typically undertake, whether that's to edit, whether that's to take down content, whether that's to post content, that's treating you as a publisher and barred by Section 230.
I'm going to add, to go back to this drafting point, they could have said that X is not liable for Y, but instead they said X shall not be treated as a publisher or speaker of Y. And I think that grammar move really opens up some interesting thoughts about why they did that and what would it have looked like to have just treated as a liability rule, just written in, services are not liable for defamation for third-party content or something. They could have written it a different way. And I think that that's one of the mysteries to me, actually. It really shows, I think, what I would attribute to Representative Cox, that he saw this vision that this model of publisher or speaker actually creates this whole disincentive And we don't want that disincentive. But it's interesting. They could have written it a different way, and they chose to write it that way. And in some sense, I think that's part of its enduring success.
Is it partially that they didn't want to assume that they knew the whole universe of what you could get in trouble for? So in other words, if you tried to list like not liable for defamation, not liable for slander, not liable for pornography or whatever, that there might be new things in 30 years that they're getting in trouble for that didn't even exist back then?
So that really is an interesting quirk, because if they had said, shall not be liable for any cause of action based on third-party content, I think they could have gotten there another way. That's not the approach they took. But because you mentioned the federal preemption of state law, the rule was very clear that they wanted a single federal standard so that we all knew the rules across the country. And so in that sense, I think whether Representative Cox was thinking that way or not, the goal was to avoid the workarounds, the plead-arounds that plaintiffs always do. Like, that's so inevitable. You're going to know that there's going to be plead-arounds. And I think that the way that it ended up structured really did solve that problem. But there might have been other ways to do it.
And when they drafted it, did Cox and Wyden, did they basically get exactly what they wanted in the statute, or at least in this section? Were there conflicts or tension in Congress as this was being drafted, or did it seem like a pretty uncontroversial thing?
My understanding, as they've told the stories about it, is that they had already passed something very different on the Senate side that this would get folded into, and then of course later struck down. But that involved a senator from Nebraska carrying around a huge 3-ring binder of offensive materials his staff had downloaded from the internet and sort of scaring everyone with it. So I think
without their consent, just like
it had like a warning, do not open, and I don't know why that story amuses me so much about senators being like, oh.
I mean, come on, if it says don't read, senators
You know they were
oh
like,
yeah.
It's like the forbidden section of the Hogwarts library.
Exactly. I wish you were that charming, actually. It's probably a lot worse. But that was sort of going on, and that was in some ways sort of resolved in the Senate. He had kind of convinced people that the internet was like a terrifying porn storm of awful, and they were like, yeah, we should definitely do something about that, and that's what would be struck down. But I think on the House side, I think they weren't in leadership, but they were both well-respected, well-liked members, and I think they took a lot of time, like, shopping this idea around and speaking to offices, and not because they were from different parties. It didn't take on a partisan, and I don't think I'm sure they had input from different offices, but there doesn't seem to be stories of any big kerfluffles on the House side. I think the final vote was 420 to 4, so the House, I think, was very unified. I don't know the extent to which everyone who voted for it understood it, but in any case, certainly Wyden and Chris Cox understood it very, very well, and maybe had enough just sort of good grace with other members that people deferred to them on this sort of stuff. So I think the fights came later because Section 230 gets rolled into the Decency Act, and then kind of they're the opposite of each other in a lot of ways, but Congress being Congress, they just smush them together in reconciliation and put them through. And then, of course, the Supreme Court goes on to sort out what remains. And then all the real fighting begins. But I think at the time that it was being drafted, I'm not aware of any huge fights on the House side.
I don't think its importance was appreciated at the time.
Right.
I mean, I think, frankly, even for years after, the importance wasn't necessarily appreciated. So I think it did fly under the radar a little bit because the Communications Decency Act was quite controversial, and that was the visible piece. And this was almost viewed as sort of, it's a tack on or a supplement, a different way of trying to encourage the filtering that really the Communications Decency Act was trying to encourage. So I just don't think the importance was understood at the time.
I would add that it was also, the Communications Decency Act was baked in the Telecommunications Act of 1996, which had significant social and economic consequences. So people were really excited about the Telecommunications Act, and then they were extremely nervous about this thing called Communications Decency Act. And then there was this other thing, like what's this other thing that was in interesting language that people weren't really quite sure what to make of it. I will point out that you mentioned how the Communications Decency Act from the Senate and the what became Section 230 from the House got put together, that's always been a black box to me. Like, what happened in the room that made the magic that put those two together? That's one of the mysteries of history. But I will add the one change that did come there that I also never been able to explain is that Section 230C1 and Section 230C2, which we haven't discussed, I don't even know if you have it on your agenda, or it's like the afterthought of the afterthought, was actually divided out somewhere along the way and given separate section numbers. They used to be part of the same paragraph. And I don't know why. I don't know who said, let's break those apart. It's been a source of great confusion because some of the courts have thought Section 230C2 is the payload, and Section 230C1 is like a defining or operative provision, which would have made potentially more sense if they were combined. But once they got separated, they should stand alone, independent of each other. But that division has actually been another mystery of history.
Yeah. So we've briefly touched on the Communications Decency Act. It might be helpful, even though this history maybe doesn't bear on how 230 is interpreted, just to give context for folks who don't know this history, maybe briefly, what was the Communications Decency Act and why does it not enforce anymore? You mentioned it was struck down by the Supreme Court.
You want to do that one? I'd talk about porn.
And I'll just say a few things. As Jessica mentioned, there was a lot of scare tactics in 1995 going into 1996 about the prevalence of pornography online and children's access to it. And so the idea was to stop commercial publication of pornography by creating this thing called the Communications Decency Act that essentially banned indecent and patently offensive material being made available to minors with safe harbors such as if you use a credit card to check their to authenticate them, then they could be allowed access to this material that would be objectionable to minors. And this was a criminal law. It was a broad-based censorship law. It went for the gusto in a sense. It wasn't like they really tried to water it down to make it constitutional. They're like, let's just ban porn on the internet. And so with that law dropped, that's what the internet community was very concerned about because it criminalized a lot of content, an unclear scope of content, and so the services were worried about their own personal liability, and so that's why Section 230 was like, we don't get to enjoy this benefit of this great little tool that's been offered here because we might be hauled off to jail tomorrow. So in the Reno versus ACLU case from 1997, the Supreme Court definitively struck down the law, said it was unconstitutional. It was a 7-2 vote on parts of it, but really it was unanimous on the core questions. This was not a constitutional law. It restricted all kinds of content that was clearly constitutional. It was written in a way that was not implementable by publishers. It was just a bad law. I'm sorry if you were involved in it, but it was a bad law.
So, it's just interesting context, and it explains, you often hear it, its full name is Section 230 of the CDA, and you would ask, well, what's the CDA? Why do I never hear about any other parts of it? So that's why. It's the only part that survived. So it's passed, and I think the very first case that interprets Section 230 is the Zeran versus America Online case, and Samir, you have a professional connection to this case. You were involved in it. Do you want to talk about?
I represented America Online in the case. So in many ways, basically the facts of the case were relatively straightforward. So many of you may remember there was a terrorist sort of bombing of a federal building in Oklahoma City. And in the aftermath of that bombing, some to this day unknown person on America Online, which for many of you in the audience may not realize, America Online was sort of the way people got on the internet, or was the equivalent of the internet back then. An unknown person started posting essentially advertisements for T-shirts that made fun of the victims of the Oklahoma City bombing. And again, for reasons unknown, those advertisements essentially said, and if you're interested, call Ken Zeran, and gave his phone number. So as you can imagine, Ken Zeran ended up receiving a lot of abusive phone calls. A radio station in Oklahoma City called him out for why are you doing this? He contacted, or the allegations were that he contacted AOL, asked them to take down these advertisements because they were fraudulent. He had nothing to do with them. AOL, depending on what you believe in terms of the allegations, took down some of the advertisements, didn't take down or didn't act fast enough. And so ultimately, Zeran sued AOL and said, I'm being defamed, I'm being damaged, and you, AOL, are being negligent for not having taken down the advertisements, or at least not taking them down quickly enough, and that's resulted in damage and harm to me. So, so this was a case in which that 230 seemed to apply, because it was, no one knew who had posted the advertisements, but there was no allegation that AOL had posted it. So it was content provided by another information content provider. There was no real controversy over the fact that AOL was an interactive computer service as defined in Section 230. And so the real question was, well, is this treating AOL as a publisher? And this is where some of what Jessica talked about earlier in terms of distributor versus publisher started to come in, because what Zeran argued was, well, no, I'm not treating you as the publisher. I'm treating you as a distributor of this content. Once I told you about it, you knew about it, and under the Smith versus California, so Smith versus California that said when bookstores don't know about content, they're not liable. That doesn't apply. I'm treating you as a distributor. You knew about the content, and therefore your failure to act was negligent, because he brought a negligence cause of action, not a defamation cause of action. And so that was the question: does this treat AOL as the publisher of the content? And we argued, ultimately successfully, that yes, it was still treating you as a publisher, because really what you were asking AOL to do was to act as a publisher, to take on the duties of a publisher, to review content, to take down particular kind of content or edit it, and that when a cause of action asks you to assume those kinds of duties, that is trying to treat you as a publisher, and that Section 230 applied. It wasn't 100% straightforward that it was. I mean, the court could have gone a different way, but ultimately it ended up siding with AOL and saying, yeah, Section 230 bars this claim and this cause of action.
Can I just add one thing, which is that opinion from the Fourth Circuit came out a little over 18 months after Section 230 was enacted. So a very rapid turnaround for an appellate court to issue an opinion on interpreting a statute. And so I think that's one of the several reasons why Zeran is such an important case, is not only did it take a very broad reading of Section 230, but it came out so quickly that it really then became the flagship precedent in the area for every other court to reference.
Was there a real danger, do any of you think, that the first court to interpret it could have gone the other way? What would have been the narrower option that could have potentially happened, and how different would things be if they had taken it narrower?
I mean, I think it could have gone the other way. And I think the most likely way would be the distributor versus publisher distinction. And to say, as Eric said in quoting Section 230, it says you can't be treated as a publisher. And there was this pre-existing dichotomy seeming dichotomy between a distributor and a publisher. And so you could have read Section 230 as saying, okay, well, we can't treat you as a publisher. We can't make you strictly liable for content that appears on your service. But if you have knowledge about the content, if you have notice, then just like a distributor or a bookstore can be held liable, you too can be held liable. What we argued ultimately, and what the court ultimately accepted, was that really what the pre-existing case law was doing was saying a distributor can't be treated as a publisher. In other words, it can't be held liable for content unless it has knowledge about that content. That really what the courts were saying was distributors have a special rule that you can't be treated like the publisher of a content unless you have knowledge. Once you have knowledge of that content that you're distributing, you can be treated as a publisher. So that the bar in Section 230 on treating interactive services as publishers applied equally to distributors, because it was just sort of a subset of publisher liability. And the court ultimately agreed with that.
I might add that the fact that Zeran pled negligence as opposed to defamation could have given the court another way of resolving this issue. We don't normally think about publisher, speaker elements in a negligence claim. And so the court could have said, if the claim doesn't reference the words publisher or speaker, then Section 230 doesn't apply. Negligence doesn't. Four elements of negligence don't reference it. And so negligence was unaffected. The court could have easily, I think, gone something like that. I don't think that was what Zeran was arguing directly, but if you just look at this cold and you say, why are they using the term publisher or speaker here when we're talking about negligence, those two are like apples and oranges. That would have been an option. And there's so many other statutory ambiguities in the drafting that, there was a lot of ways I think the court could have gone if they wanted to reach a different outcome. But clearly the authoring judge of that opinion saw the speech and publishing implications of the case. And I think that really mattered. Like the judge got that underlying point, and that's why we got the opinion we did.
I think we were very fortunate in the choice of judge. It was just Judge Wilkinson, who was the chief judge of the Fourth Circuit, who was very much a strong First Amendment advocate. And so I think it was very important that we ended up with that judge.
And potentially he's a well-respected judge, considered a conservative judge generally. Do you think the fact that he wrote it also might have weighed in on its influence in other circuits?
I think it did. I mean, he's the chief judge of the Fourth Circuit, as you said, well-respected. So I think it did have an effect.
And also, I mean, sorry, I'm maybe biased. It was your opinion more than mine, but it was a good opinion. Like, it addressed all the things they need to address in a very clear, understandable way. And so when other courts read, they're like, I see what the judge is saying. I understand it. It seems reasonable and rational. And I think that helped a lot too.
Sure.
Yeah, and I'm struck by, again, I'm maybe looking forward a bit to today where there's somewhat of a partisan valence to 230, or you start to see conservative critics of it. But I want to transport back then. Was there any sort of conservative liberal split at the time, or not really? Did it?
Not really, although to be fair, Section 230 at this point was flying very much under the radar. It wasn't a political issue. I mean, it really was, for 20 years, I think it flew under the radar. It wasn't something that got a lot of attention politically.
Yeah.
So, but no, at the time, there wasn't really a political valence to it.
So the Zeran decision is influential, as we said. A lot of other courts look to it. We get some early other cases. There's a Florida state case called Doe versus America Online. There's another appellate case called Blumenthal versus Drudge. We can discuss those or others, but does everyone basically take the same approach as Zeran? Is there any nuance to the differences? How did those early cases go?
I mean, I litigated both of those cases as well, and
You're the right person for the
Yeah, you should answer this one.
they were different. The facts were quite different and made them more challenging. So Blumenthal versus Drudge was a case. I mean, Drudge still is around. He, at the time, was famous or infamous for what was called the Drudge Report, which was a sort of a broadsheet, an online broadsheet that had a lot of stories, many of which weren't particularly accurate, but he was quite popular at the time. And so America Online contracted with Drudge to put the Drudge Report on AOL, paid him, and in the contract reserved the right of editorial control over the Drudge Report and said, we can, before it gets posted, engage in editorial discretion. So the Drudge Report posts a story about Sidney Blumenthal, who was a White House aide at the time, essentially alleging that he was engaged in domestic abuse. And Blumenthal sues AOL, as well as the Drudge Report, for that story. And here the argument was, well, this isn't really third-party content. You contracted for it. He was your contractor. You had the right to edit it. You contractually had the right to edit it. And so really you should be held responsible. You at least partially were responsible for the creation or development of the content, which under Section 230 makes you an information content provider, because the definition there says if you created or developed the content in whole or in part, you're an information content provider. So the argument was, well, by paying Drudge and by at least reserving the right to editorial control, you were at least in part responsible for the creation or development of the content. That was a close case. We could have easily lost that case. But we argued that, at least with respect to the particular story at issue, AOL didn't in fact do any editing. He was an independent contractor, not an employee, and under common law, that means AOL had no control over exactly what it is that he wrote or how he went about writing it. And the court ultimately, very reluctantly, very clear it was being very reluctant, was persuaded by the Zeran case and said the way that the Zeran case was written, that Section 230 barred liability in that case. And then briefly, the Doe versus AOL case, which was in the Florida Supreme Court, was a tough case for a different reason, because it was terrible facts. It involved the advertisement of videos of child porn. And so the parents of the victim of the child porn sued and said AOL knew about these advertisements and didn't take them down and should be liable. And ultimately, the Supreme Court, by 1-vote margin in Florida, essentially deferred to Zeran and said we have to defer to the way Zeran has read Section 230, and because this was content not in which AOL had no role, it shouldn't be held liable.
Thank you. Anything to add? Well, yeah, you're the expert on these cases. So then we get some Ninth Circuit cases, and the Ninth Circuit, obviously, you can understand how they would be influential in tech, given so many tech companies headquartered in California, which is within the Ninth Circuit. We get a few called Batzel versus Smith, Carafano versus Metro Splash. Again, I think these also started to have potentially very bad facts as well, maybe started to get people second guessing or thinking about, do we really want 230 to have this breadth? But what's the reaction to cases like those, and does that kind of continue the Zeran trend as well?
So I would look at both those cases as the beginning of multi-decade angst in the Ninth Circuit over limits to Section 230, and saying Section 230 is defined by Zeran, we support, but there's an exception. And since then they've done, I don't know, 15 exceptions or something like that, and those were kind of the early starting points to looking at the exceptions. The Batzel case involved someone who emailed information that was then forwarded on to an email list. And the court said, if it's forwarded out by email, Section 230 ought to apply to it, no different than if it was posted online. It's still third-party content, it applies, unless the sender had meant it to be private information, a private email, as opposed to one that's intended for public posting. And you look at it and say, that makes complete sense. I totally support that distinction, that if it's not intended for publication, but then the person chooses to publish anyway, there's a bunch of downstream consequences that the sender couldn't contemplate. Maybe Section 230 shouldn't give a free pass to the person who makes that inadvertent, unintended publication. And yet, what it does is introduce another fact question for a plaintiff to say, okay, there's a distinction here. Section 230 generally applies, but now I can argue around Section 230 by saying that material was not meant for publication. And that's just like, the Ninth Circuit has done so many of those over time. And it's really just a sign of how judges are just constantly conflicted by what Section 230 says as interpreted by Zeran, which is very clear, and their intuition like, oh, I don't know about it in this case. And so that's how I would view both of those cases. The Carafano case involves pull-down menus and who's responsible for when you pull down menus, and ultimately got munched in the roommates.com case where they essentially wiped away the case.
I want to pick up on something that Eric said, which I think is actually quite critical and important as to why 230 is important. Eric mentioned that the Batzel case sort of introduced a factual issue. And really the power of Section 230 is that it allows the resolution of most of these cases on a motion to dismiss without getting into factual issues. And the reason I say that's really important is because if you think of Section 230 as a case, as a statute that's intended to promote free expression, what that means is that you want the platforms to leave user content up on their system and not, for example, be subject to a heckler's veto, that every time someone calls or gives them notice and says, hey, this is defamatory or this is wrong, that they just take it down. Because that, in essence, is going to allow people to get content taken down and is anti-free expression. But if you're a rational interactive computer platform, if you are facing potentially hundreds of thousands of dollars of litigation costs because someone is going to say that a post is defamatory, your rational answer, your rational course of action is to take down that post when you receive that notice from somebody, because if you weigh what's the value to me of keeping that post up there versus hundreds of thousands of dollars of legal costs, you're going to take down the post because it's not worth the hundreds of thousands of dollars. And so the fact that Section 230 allows you to get rid of these cases quickly, and that the early precedents made it quite clear that they were going to win those cases, which deterred, I think, a lot of plaintiff lawyers from bringing the litigation in the first place, was quite critical in terms of fulfilling the purpose. Because if in order to win Section 230 cases, you actually had to litigate the facts, as in Batzel, or Section 232C2 talks about taking things down in good faith, and good faith is a factual issue. If you actually litigate the facts, go through summary judgment, that would mean platforms, by and large, would then just take down the content because they wouldn't want to undergo all those litigation costs. So in many ways, that's the power of Section 230, and the fact that Zeran sort of decided as a matter of law in those early cases, decided as a matter of law was quite critical to making it effective.
Can I add something to that? I just want to point out, for those of you who are familiar with old school journalism, the publishers of old school journalism generally were pretty willing to invest in defending any item of content on principle, even if that particular item of content was not financially worth the cost of defending it. So, if there was a threat over a newspaper article, newspapers like, we're going to fight this because we recognize how important it is that we establish the right principles. Internet companies aren't built on journalism principles, and frankly, they're just in it for the money. Like the idea is if any particular item of content is going to trigger lots of defense costs, get rid of it. It's not complicated. That's just rational maximizing.
And the volumes they're facing are ridiculous.
But to note the shift from the old media to the new media, the old media would have viewed this as philosophically important, and the new media doesn't.
So, and I think what you mentioned about litigation costs is so crucial, and non-lawyers may not know that the American rule in general in American courts is both sides pay their costs almost no matter what, and only in rare circumstances is the loser forced to pay the legal costs of the winner, and that's different from some other countries where the rule is that the loser pays for both costs. So American lawyers sometimes have a phrase, the process is the punishment, which means even if you're going to win eventually, it can still not be worth litigating a case you're going to win if the cost is so high or the time is so high. So one thing that's striking me from this discussion is we're talking about how influential this appellate court decision is, but the Supreme Court never takes any of these cases. The Supreme Court could have established definitively an interpretation early on or even within the first decade of Section 230. Any thoughts on why none of these cases are taken up by the Supreme Court? We only had the first 230 case reach the Supreme Court a couple years ago, and that kind of turned out to be a dud. They didn't really decide anything about it. But why did the Supreme Court let this just percolate and be decided by influential circuit court decisions?
It's a good question. I mean, several Supreme Court justices, most notably Justice Thomas, have expressed a fair amount of skepticism about the prevailing interpretation of Section 2 that have made pretty clear that they would come out differently. But as you said, the court had a chance a couple of years ago to do that and punted. And I mean, who knows? It's hard to know. I think my own speculation is that once the court got into it, it realized it was far more complicated than it may seem, and that a rule that tried to cut back on Section 230 could very quickly have complicated consequences for free speech, and that there's not an easy line to draw that sort of says, well, Section 230 applies here but not here. And so I think ultimately the court backed down because it realized there was no simple, easy way to do this.
Yeah, I think the remedies got more complicated than, for people who don't spend as much time with Section 230 as a lot of us do. It all sounds like, oh, it feels like a lot of protections. There's people getting hurt. But when you start really thinking through why and what incentives you're creating, I think that has a huge impact on, as you said, it's just not that. There has been one change to Section 230 since it was passed, which was the sex trafficking. And that has been, I think it came with a fair amount of harmful and unintended consequences that people, could never be happy with. A lot of that activity was driven into much more dangerous places, and it really wasn't the fix that everyone seems to think, if we just curtail it or get rid of it or tinker with it, everything will be better. It's just not the case, and maybe the Supreme Court was aware. But there had been other cases in lower courts where, Section 230 was pretty explicitly made to cover like search engines. So that was about sort of like the arranging of things. Is that, is that covered? So it's been pretty consistent going in that direction, where with Gonzalez at the Supreme Court, I was kind of surprised they didn't just say, all these other courts have seen it this way. This seems like not much different than how you arrange search results or how you do other things, which they said, but they didn't rule. So yeah, I agree. I think it's much more complicated once you start really looking into how all this works and why it works, and at this scale. which is it's just something completely different than newspapers and bookstores and all that.
I would add one reason why I don't think the Supreme Court took the case until the 2020s is that Zeran really did establish a national precedent that was not really deviated from materially for at least 15 years. And so there wasn't the kind of circuit conflict that normally the court is attracted to. I think today there might be a number of circuit conflicts that the court might be willing to intervene on, but that's a much more recent phenomenon. So for a long time, it seemed to be working. Everyone seemed to be in agreement about the Zeran standard.
Right. So Jessica, you mentioned search engines, and this is another example where the way people interact with the internet, the entry point to the internet changes from, if you think about 1996 to into the 2000s, it's less about America Online, unfortunately, for your former client, and Google becomes the de facto starting point for the internet for everyone. And so we do have a case about Google. I think it's called Fakrian versus Google, and it extends Section 230 protections. Was that at all in doubt, that with search engines being different maybe from what they were when Section 230 was developed? Was there uncertainty about how it would apply to this new way that people enter the internet?
I think if you accepted Zeran, there wasn't too much doubt, because if you just walk through those three elements, it's an interactive computer service. Clearly, it's pulling in third-party content. Google's pulling in third-party content, and if you're going to hold it liable for defamation or any of the, by then courts had sort of said, virtually any kind of cause of action that's making you liable for third-party content effectively is treating you as a publisher. And so, given the prevailing case law, I think its application to search engines was relatively straightforward, actually.
Mm-hmm.
I would actually suggest it is not straightforward, and it's because much of the content that is in a search engine index was not expressly requested by the third parties to be in that index. Google makes the affirmative decision to pull it in, and so you could make a distinction, say, if people submit the content to you, then it's third-party content. If you go grab it, you've made an independent decision that strips the authors of some agency. But that's not at all the way that people have thought about it. For the reasons that you described, if you go through the elements, it looks like it meets all the elements. I would add that there's been a parallel genre of cases involving search engine protection under the First Amendment that has also validated the search engines from liability under First Amendment grounds. And so in some sense, Section 230 is almost the tail of the dog as opposed to dog in that circumstance. Even if Section 230 weren't applying, the First Amendment would likely protect the search engines for the same claims. However, Section 230 has the benefits of being a statute that is cheaper to defend and perhaps clearer than the First Amendment application.
All right, we're getting close to the Q&A period, so I just want to remind folks watching online, you can still submit questions via the event's webpage in the little box, or on our Facebook, YouTube, or on X. So let's go big picture to the development of the internet. What did Section 230 accomplish? And I guess the best comparison point might be Europe, which did not have Section 230. So Cox and Wyden, they passed this law, they wrote it trying to avoid what they saw as the downsides of the prodigy rule, the pre-230. How do you think the internet might have developed differently in an alternate universe where we don't have 230 in the 1990s and in the 2000s, let's say the first 15 or so years of Section 230? And how, if at all, did we see the internet in fact develop differently in other countries with a different legal landscape?
I think in terms of how it develops, people often, certainly in the political realm now, people think of 230 or talk about 230 as protection for Google or protection for Facebook, and obviously it does apply to them. But in many ways, it's actually more important for the smaller providers. Mm-hmm. Because, and it goes back to the point I was making earlier about litigation costs, that for, Google and Facebook have the resources and the lawyers to defend a fair number of lawsuits. The smaller providers don't. And if they were faced, if a Yelp or another site that does reviews, that allows for users to post reviews, were faced with constant litigation threats every time someone posted a critical review, then they would either basically take down any critical review or anytime anyone complained about a critical review, or they wouldn't be able to provide their service at all because they just wouldn't be able to afford the litigation costs. So I actually think Section 230 in many ways has been most critical for the smaller providers, the ones that don't have the resources to defend the litigation. And so in that sense has allowed for the flourishing of different kinds of niche services that you wouldn't necessarily have seen if you had the possibility of litigation for all third-party content.
Yeah, I think it's just what it's allowed it to do is be us, be us talking to each other more than sort of like us being talked at by a sort of vetted and sanitized menu of items. I think there would still be things on the internet, there would still be the internet, but I don't think social media and reviews and a lot of other examples would be as prevalent. And now, of course, I think that's all the good stuff. But of course, because it's us, it's human beings, it's also all the problematic stuff. So now we find ourselves here, defending sort of the messiness of it. And some people giving more value to that than others. But I also think, the instincts to emphasize certain things, in Europe as an example, are just different here. I think that Cox and Wyden and a lot of people at the time had a real enthusiasm for innovation and free speech. All of these like good free speech judges you run into and things like that. It kind of all came together in not a particularly coordinated way for things like Section 230. And I think in Europe, it's always been and is maybe even more now. There's more of an emphasis on privacy regulation and litigation, and more of an approach of, they're a little more uncomfortable with the liability shields, and they're a little more into like if someone lets you know, take it down, and I think that's just sort of the political impulse there is a little different than, I won't say the internet is not the Wild West, but we have a certain love for Wild West things here in the US. Which I'm proud to say. And I think that it just was a little bit different of a mindset that presented itself in a lot of ways. Chief among them, I think, is Section 230, but not the only thing. And as you mentioned, our tort system is very different, right? I mean, if you have loser pays laws, you have a lot less exposure to being smothered in the cradle of your garage while you and your college dropout are creating the next great thing. And I think the point about the small organizations benefiting from it most is so true. And also I would say, that's how all these big guys started out. Like if you want to make sure that someone from someone's garage is going to give these guys a run for their money and you're worried about that, a really bad thing to do is to pull up Section 230 sort of behind you and say, okay, well, we had this nice long runway and we had these protections, but no one else gets it because it's, the people who want to repeal it are always, to me, the same people who are worried about the monopoly part or the too big part. And I think that's a sure way to freeze the big guys in place because they're the only ones that could afford to go on without Section 230. So if we've already started out rolling the dice, let's keep going.
Right.
Can I amplify a couple things that Jessica said? Back in the mid-1990s, almost all the content that we consumed was paywalled content. Newspapers or magazines were paywalled, books were paywalled, cable TV was paywalled. And so the most likely scenario for the internet that it was going to evolve into a series of isolated paywalled gardens that were just like the model that we were all subscribing to at the time back in the 1990s. And the troika of events, Section 230's passage, Zeran interpreting it, and the Supreme Court striking down the CDA part in the Reno versus ACLU case, the combination of those three things opened up this door to a whole new way of us talking to each other, as you described it. And that's what we call the Web 2.0 revolution. It was very much a product of the legal environment here in the US, and it is what defines the internet today. It's what's created extraordinary wealth for the companies, but it's also what gives each and every one of us the voice to speak up. If you look at other countries, many of them have some homegrown user-generated content services. Often it's only one, major player, and there's none of the kind of low-scale entrepreneurship stuff taking place that we see here that has led to the progressive development of new giants. And so in that respect, the U.S. really did create a new opportunity, not only for us, but that backfield across the globe. What wasn't taking place in those countries, the ability for people to talk to each other there, the U.S. services are the ones that came in and actually enabled that. And so it really reshaped how everything worked. We got away from the paywalled garden model to create something very unique. And you say, what does the model look like without Section 230? And that's what we're facing today.
Yeah, that's a great point. Let's start taking some questions. I'll start with an online question, and please keep the online questions coming via our webpage, Facebook, YouTube, or X. So first question is about essentially the alternatives for people who are harmed by online speech, given the Section 230 protection. Anonymous questioner says, 230 aims to hold the third party rather than the platform responsible for speech, but to what extent have third parties actually been held responsible? To what extent does the difficulty of establishing identity or even age on the internet defeat this intended accountability?
So I'm going to take a crack at that. First, there's this assumption that it's hard to find defendants. And that's actually, I think, been increasingly less credible, that it's actually pretty hard to do anonymous or pseudonymous activities online that allow you to avoid liability. It happens, but I think that that's been overblown as a threat in a lot of cases. There are many circumstances where people who've done terrible things have been held accountable. Interestingly, not in the Zeran case. One of the great internet law mysteries is who did dirty to Zeran. We still don't know that answer today. So that was a successful one, but that's really the exception to the rule. But even if we accepted all that, the whole point of Section 230 is that the services are able to intervene and to try to help in ways that they might not otherwise do without Section 230's protection. So if we think the problem is that we need someone protecting victims, Section 230 is actually part of the solution.
Just to pick up on that last point, when we talked earlier at the beginning about distributors and the fact that distributors could be held liable only if they had knowledge or knew about the third-party content, if that were the prevailing rule, which would have probably been the default prevailing rule, what that does is create a disincentive in many respects for doing the kind of monitoring of your service to find harmful content. Because if the only way you're potentially liable is if you have notice or know about that offending content, there's a real incentive to see no evil, hear no evil kind of a thing, and not employ people to monitor for content or to employ now automated processes to look for unlawful or harmful content, because by doing so and gaining knowledge of it, all of a sudden you're potentially liable, whereas if you don't do it, you're not liable at all. And so that actually enables or opens the incentives for that kind of monitoring.
And I'm going to add to that just that I don't think there's a real scenario where services would offer mass market offerings and not do content moderation and say we can't do it because of legal liability, so just have at it, everybody. Those are not scalable models. Those are not commercially viable models. And so it really is either somebody is doing the moderation with or without liability, if it's possible, or there is no service at all. Those are really the binaries. There's not an intermediate mode.
And that's why the small providers really need Section 230.
All right, let's go to questions in the audience. Please give your name and your affiliation and keep it short. We have one here in the front row. Short, under 60 seconds, and an actual question, not a comment.
Okay, Stephen Allen, Dr. Stephen J. Allen, National Legal and Policy Center. If I can make a historical addendum, because this responds to some of the things that were said. I was a journalist covering the early days of the internet. I was in the room particularly among conservative groups when they were fighting over these issues. And you basically had a split between, you might say, Cato and Heritage. One way would be, on one hand, the sort of pro-technology conservatives, Rush Limbaugh, Newt Gingrich, George Will. They were more on the free speech side. Then you had religious conservatives, traditionalist conservatives, and in some cases, what were that era's version of neocons. So, for example, William Crystal's Weekly Standard magazine had a cover story, "Smash the Internet," which was about essentially strangling the Internet in its crib. And so what happened was that both these, in the case of Gingrich and Limbaugh, they had to be walked very carefully because they had constituencies who were on the other side, who were religious conservatives and traditionalist conservatives. But there was no question what side they were on. And so both these points of view got incorporated into the Communications Decency Act, and essentially they said, well, we'll let the courts sort it out. And that's exactly what happened. So that's my point of view, and one that doesn't get in the history books, but I figure should be in there.
Reactions or agreement or disagreement? Let's get this side. Any questions in the audience? We have one right behind him, actually, here.
Thank you. Steve Del Bianco of NetChoice. And the question is provoked by what Eric brought up regarding the balance between First Amendment and Section 230. When NetChoice sued Texas and Florida after January 6th over their content moderation mandates, it was a tough dilemma. Should we argue 230, right? Or should we argue First Amendment? But we looked at the composition of Congress and the anger among conservatives and said if we won those cases based on 230, it might invite Congress to repeal or amend 230. So we chose the First Amendment. I'm glad we did, and those courses were affirmed in the Supreme Court. But should we have done differently? Do you believe that 230 is the better way to go, or First Amendment, and were we too careful to avoid political risks?
I don't think you're going to avoid the political risk regardless. So, if that was your motivation, I don't think that really makes much of a difference. But thank you, NetChoice, for the work that you're doing. It really is blazing a trail, and we're grateful for it. And ultimately, I think it really gets down to the fact that we need both Section 230 and the First Amendment. They're actually both important. First Amendment because it's immutable. Section 230 because it gives the fast lane to resolution. So from my perspective, we want both of them to be integral and vital. And so in a sense, getting the Moody decision from the Supreme Court reinvigorated, at least temporarily, the First Amendment, and that's really helpful. But Section 230 is also part of that conversation. So, please keep doing what you're doing.
We have a couple online questions that I think are similar, so I'll read both of them. Philip Ellison asks, given the debate about algorithm, AI-generated search results, surveillance with data collection, would it be fair to say that 230 simply permits abuses such as bias and censorship that an old-school publisher could never get away with? And then similarly, we have an anonymous question. If platforms profit from algorithmic amplification, should that change how we think about liability under Section 230? So I see both of those questions basically saying tech is different in significant ways from the old school pre-tech era. We now have amplification. This was part of the issue in Gonzalez versus Google. How should Section 230 think about that when it's not just we're hosting speech, but our algorithms or AI might be.
I'll say something in a moment, but I'll just point out, I think the future panels are also going to talk about that. So
yes, true.
I think they're going to help answer the question. Sorry, I'll wait in a moment.
No, I was going to say, I disagree to some degree with the premise of the question, which is that old school publishers didn't have a point of view. In fact, a lot of them did have a point of view, continue to have a point of view. So I actually think it's part of the reason Section 230 is critical is that we want services to be able to have a point of view or to have niche communities and say, we actually just want to talk about cats, and if you have a post about dogs, we're going to take it out. I actually think that freedom is quite important, and we want to allow services to have different points of views, and then users can choose whichever point of view or whichever service that they want to interact with. As we'll leave for the future panels, I think the question of how this applies to AI, how it applies to algorithms, the application to algorithms is quite critical. I mean, we haven't talked about, there was a relatively recent Third Circuit case involving TikTok that found that Section 230 didn't apply to the context of algorithms in a particular case, which is actually one of the biggest breaks that we've seen from Zeran in, I think, in the interpretation of Section 230. So I think those issues are still to be, still need to play out, but we won't, I'll leave them for the future panels.
I'm going to add, the mere act of publishing content, whether that's gathering, organizing, or disseminating content, is a bias. That's the whole point. It elevates some content over others. So the idea that there could be some kind of non-biased publication is incoherent. That doesn't make any sense. It's not possible. But also, especially if you go back in U.S. history, you can go to other countries' histories too, like publishers have absolutely always had a very strong and in some cases extremely partisan voice in their publications. That's just media. And what's happened over time is an fetishization of what I might call both-siderism, that the solution to the inherent bias in publication is to try to treat both or all sides equally. And I support publications that do that. If that's what they choose to do, that is a valuable viewpoint. That is not the only approach to publishing content. And as we've seen, it also has its own inherent risks, because by both-sidering issues, you elevate voices that might actually not be credible. So from my perspective, we have to let go of this fantasy that there's some kind of unbiased utopia out there that we can achieve, and Section 230 has taken us out of that utopia. There has never been a utopia, and if there is, Section 230 is getting us closer to it.
Yeah, my colleague at CDA, Wayne Cruz, whenever we get questions asked like this, says that his new slogan is going to be all search results must appear first. So you just
in chronological order too.
and simultaneously in chronological order, and controlled for who might see it, but also completely free and everything goes. It's just, there's just inherent bias in just, just like as a newspaper orders, what stories are going to include that day. Forget about how they cover them or what they include in those stories. Those are just the decisions that people in the media make every day. And the only time that becomes problematic is when there's only one source of information. That is certainly not the situation we find ourselves in today, where there's more information and more sources available to you than all time, right? The only time that I would care if the New York Times one way or the Wall Street Journal the other way was biased is if they were the only newspapers that existed and the only place I could read the news. So the objectiveness is a fantasy. And by the way, who would decide what's objective? Because my opinion of what's objective sure as heck doesn't look like probably most of the people I know. So we just have to abandon that and get over it and say, the best solution here is more points of view and more options for people.
Yeah.
But actually, and Jessica, you raised a really interesting point, and something that I think deserves more discussion. We are seeing the emergence of what we might call media deserts, of places that are underserved by commercial journalism, and the internet is often the gap filler for that. It's actually the solution again to that problem. But if the enemy is diversity of information, we should look for solutions to that problem, not to then say all sources must then follow a single protocol for how they share and publish information. The monoculture of editorial practice would actually be its own problem.
Yeah, I think that's in a quick example of that in action is there's a lot of concern over local news and local even broadcast news. And I recently came across one of the big owners of many broadcast stations has made an app. And you can go on their app of their 80 TV stations or whatever, and you can see your local news anywhere you might be from. So if you are a transplant to DC, like all of us are, and you are itching to see the weather in your hometown, you might be able to do that. And I think that the internet provides those solutions that people are impatient for. And I think the more information that's out there, the better. The more options, the better. And that's often the solution that the internet brings. To get caught up in, I didn't like what they took down or I didn't like what they left up is, I think, largely beside the point.
Yeah. More questions? We have one over here on the row.
Thank you. First, I want to thank you.
Name and affiliation.
Janice Walt Grenadier. I'm the founder of judicialpedia.com. We've had over 7 million views in the last couple of years, and 230 has saved me. It's a platform that people can put up their judicial complaints, their cases in the courts, their complaints against judges, etc. In the state of Virginia, though, this is a problem that's coming up, is the Supreme Court is lobbying the legislature for a law that you can go to jail if you speak about a judge on the internet. And like I said, 230, I've gotten several cease and desist letters by very powerful lawyers that have gone away when I brought that up, because when I contacted the people, they said they could prove the truth. So my concern is, how are we going to fight the state laws or that might go through or that are already through that are going to take away the freedom of speech before it's even litigated? And
Sounds like you should join NetChoice.
I was going to say, do we want to get Steve Del Bianco to answer
We'll
that
introduce
question?
you to Steve.
That's the guy you need to talk to.
The other thing I'd note is, although Section 230 has an express exemption for federal criminal law, it doesn't have an exception for state criminal law. So state criminal law is actually preempted by Section 230.
But the point is that I think you're raising is somebody's got to prove that in court, or you're going to continue to get the harassment and the threats from plaintiffs or the state that you're violating this state law that's currently on the books. And that's part of Section 230 is the solution to that problem, but you still bear the cost, or somebody's going to have to bear the cost to overcome that. And it's an unfortunate side product of our legislative process that the legislatures manufacture laws that impose costs on others, and they don't bear any consequence for that.
But you guys have done a great thing. Thank you.
Thank you.
Thank you.
More questions in the audience? I see one here. Wait for the microphone, please.
Yeah, John Bushgood, doaskdotell.com. I'm the author of a series of books, writing a fourth one. What I wanted to just ask you about, in the early days from the late 90s to about 2008 to maybe 2010, when the social media companies started becoming much more influential, isn't it true that it was mostly search engines that made people effective, just even in Web 1.0? I was very effective with that, even though I wasn't very commercial about it, with the issue of gays in the military, the way it was debated back in the 90s and the early 2010s, until it was finally repealed in 2010. I think that made me very effective in that particular issue because of the nature of that issue. Was very amenable to people looking things up on search engines. Whereas today, it seems to be all about algorithms and popularity and social media, and now we're getting into age verification worries about kids and everything. It seems to have changed a lot right around 2010, 2011, 2012. Is that true? It seems to me I didn't have to have a big company and a lot of money and a big YouTube channel to be effective. I was effective just with being free Google search engine. That all changed around 2010 with the algorithmic way of doing things. Is that true? Is that your experience?
Thank you. Respond.
I might offer that there's been maybe even, we could say, 4 waves of discoverability online. The first wave was old school directories, or just email promotions, or kind of talking to each other in a very inconsistent way. The second wave was search engines. But you said something that says, I'm worried about the algorithms and the social media. Search engines have algorithms too, and they were prioritizing and deprioritizing content based on their own standards. The third was social media, which is eclipsed in some ways search engines, such as many Gen Z will now view TikTok search engine as a more valuable search engine than Google. And the fourth wave might be AI. The generative AI is now the search tool that people are using. And so I think they're all good. I wouldn't pick one over the other. I'd say they're all tools to get to the end, and we should celebrate all of them. But I think thinking that there's some kind of funky algorithm that we should fear in one of those and not the others, I can't make any distinctions in the fact that they're all algorithmically driven and they're all subject to lumpy inconsistencies in terms of bias and outcomes.
We might have time for one more question. I see one there in the back, one row behind the cameras. Please give your name and affiliation.
Yes, my name is Roger Cochetti, and I was at the time of the director of internet policy for IBM, and had a somewhat of a role in this. And I think, as a matter of setting the history straight in all of this, I think it's important to recognize that the mood of the time was very much driven by a point that's already been made, and that is fighting porn. I mean, we got, IBM had a big footprint, so we got lots of reports of radio commentators and pastors complaining about internet porn, and there was telephone porn, and the Time magazine cover story probably captured the mood of the time. So I would say well over 90% of members of Congress who supported this had no idea what it actually said. What they thought was this was fighting porn on the internet. And I vividly remember one powerful member telling me, listen, I just want you to know that the reason I'm supporting this is so that when my opponent comes after me and says, you're allowing porn on the internet, I could say, IBM told me this is how to fight porn on the internet. And, there's some truth to that. But there was one wording issue I'd like to ask the attorneys here who are knowledgeable about this that was, I think, very important, that's rarely discussed, and that is, or otherwise objectionable. Now, otherwise, what it said is that you can take down salacious or pornographic or whatever, blah, blah, blah. And then it also, at the end, this is section 2, said that you can also take down otherwise objectionable content. And, I would say this has had a long-lasting impact, but it's rarely discussed. And I'd hope people on the panel could talk about the significance or otherwise objectionable. Thanks.
I'm going to say very briefly, because I know we're, CEI made a podcast last year all about Section 230. You probably know more about it than anyone else on earth after today, but if you want more. And the title of that podcast is Otherwise Objectionable. So I'm very familiar with it. And I think what it means is, and all the other things that might need to be taken down that we haven't thought of. And I think that's an indicative way that it was written in a broad, forward-thinking, somewhat open-ended way, because we, as you were talking about the 4 waves of we couldn't have predicted all of that. So I think that's my explanation for that phrase.
Yep. All right. We're out of time. Let's show appreciation for a fantastic panel. That was wonderful. So we're now going to take just a brief 5-minute break. If you're here in the auditorium, we'd ask you to sit tight. We don't have a lot of time. We're going in 5 minutes at 11:30 Eastern for our online viewers. We're going to come back for a virtual fireside chat featuring Senator Ron Wyden of Oregon, moderated by Jennifer Huddleston, Senior Fellow in Technology Policy here at the Cato Institute. Thank you all.
Thank you, and welcome back to our Section 230 at 30 event. I am very excited to be moderating a fireside chat with Senator Ron Wyden, who is one of the two authors of Section 230. Senator Wyden has been one of Congress's most prominent voices on technology policy and the internet for nearly 3 decades. As a member of the U.S. House in the 1990s, he co-authored Section 230 with Representative Chris Cox. Since joining the Senate, Wyden has remained a leading defender of the provision, arguing that it protects free expression, supports innovation, and enables platforms to moderate content without crippling legal risk. Beyond Section 230, Wyden has built a reputation as a consistent advocate for digital rights, championing issues like strong encryption and government surveillance reform. Throughout his Senate career, Wyden has positioned himself as a lawmaker focused on preserving an open internet and its benefits for innovation and consumers. Please join me in welcoming Senator Wyden.
Jennifer, thank you for that.
Senator Wyden, thank you so much for joining us today. You know, I think back in 1996, the idea of a virtual fireside chat would have been a bit hard to explain or imagine, but at a time when only less than 1 in 4 Americans were even using the internet compared to today's nearly 90%, you and Chris Cox were really thinking about it differently. How and why, back in 1996, did you come up with the idea for Section 230 and understand why it might be important?
Jennifer, first of all, thank you for that very inflationary introduction and the gracious, build up. And what I can tell you is we were thinking then about some of our priorities today, like a free First Amendment, because that's a bedrock kind of value with respect to communications. And, we were thinking about innovation. I heard you touch on that. And ultimately, it comes down to users. And, in 1996, Congress was going back and forth on pornography. I came to the Senate and they were off and about in the cloakroom sharing pictures of various kinds of concerns they had that was pornographic. And Chris and I saw that they just didn't have a proposal that would really help the internet. It would kill the internet in its infancy. So when everybody else was thinking about censoring the internet, Chris and I wanted to allow platforms and networks to go out and really do their job in terms of helping users without being sued for trying to moderate their sites. So basically what I can tell you is the two of us felt that we just had a crummy choice. You could either police your website and be liable for anything that slipped through, or you could not police anything. And basically, then you could say, oh, we're safe from lawsuits and everything's fine. So ultimately, what we wanted to do then, Jennifer, was fix the moderator's dilemma. And we were able to do it and say sites can promote some content, limit others, add warnings, and block the harmful stuff and not get worried about being sued. So ultimately, the authors of the bill put in Section 230. They kept their provisions as well. And at the end of the day, after Chris and I held our breath, the Supreme Court struck down a bunch of stuff. Basically, they struck down the whole rest of the bill, but kept what we were thinking about. And now a lot of typical folks who want to share information, and back then they had never shared information before like this, they would have a chance to do so.
I want to talk a little bit about Section 230 today. The law has had criticism from those on both the left and the right, often for different reasons. And I think it's been very exciting to see both you and former Representative Cox really trying to explain what was intended by the law and what was meant by the law and how you saw it playing out in the internet as we know it today. What do you think is the most misunderstood thing about Section 230 right now?
Well, people get lost in what we're actually going about trying to protect. And ultimately what Chris and I were interested in was making sure that we didn't hurt startups, that we didn't hurt the little guy, we didn't hurt people who don't have power and clout, and we wanted to help people who didn't have political action committees. We weren't talking about the big guys. The big guys can always take care of themselves. We were for the little guys. And, we always thought that people like Google could survive an avalanche of lawsuits that would follow repealing Section 230, but say goodbye to small guys, Blue Sky, any small website that hosts people's content. And critics gloss over that it's written right into the statute that Section 230 actually protects the users of the platforms as much as it does the platforms. And without 230, you could say goodbye to people who didn't, again, have big pocketbooks and big bucks. You could say goodbye to retweets, Reddit moderators, Wikipedia editors, and the ability to rapidly share information online. All of that really depends as a core kind of aspect of the law on Section 230. So people do read a lot of politics into 230 where there is none. Sometimes they don't get the politics right. We recently had a floor discussion in the Senate, and they were talking about how, Chris Cox and I were the friends of, big tech and the like. And I said, are you kidding me? We're the ones who have the sponsorship of all the little guys and the ACLU and the First Amendment supporters. And those are the people that we cared about in the beginning. Those are the people we still care about. And we managed to have platforms to host speech from across the ideological divide. And so Rumble, Truth Social, for those, Trump supporters and X, they all benefit just like everybody else.
Section 230 at the time was a very forward-looking law. As I mentioned, we didn't necessarily know what the internet would become. And if you were thinking about the platforms it applied to at the time, they are platforms that probably many in this room might not even remember anymore. We were talking about the days of Message Board, of CompuServe. In our last panel, we talked about some of the early cases involving AOL and some of the other players. But one of the things about Section 230 is that it's proven to be remarkably adaptable. How do you think about Section 230's ability to adapt to continue to support users' speech online? And how do you think Section 230 will evolve as we start to discuss AI?
Well, certainly 230 and the core kind of concept we had in mind is still relevant because it establishes very simple principles for a wide variety of internet services that take us into the kind of next generation of technologies. The principle, for example, that the person that hosts your content on the internet isn't going to be liable for what you say was a bedrock principle years ago. It remains one now. And, to me, what Chris and I set out to do is to make sure that people had the freedom to express themselves online, to share information, and we kept it with the core kind of principles. Now, I don't know what the speech forums of the future are going to look like in every kind of particular, but to pick up on what you correctly said, Jennifer, nobody could have predicted how important user-generated video content would be back in those days when everybody was all lathered up about AOL. For better or worse, it sure looks like AI is going to be part of the future of online speech. 230 will protect forums that host AI-created works as well as the AI-based systems for organizing content and the users of the forum for the content. I do want to emphasize, though, that we've been very clear that 230 should not protect AI companies over claims about the content they generate. And I've been very clear about that, is that, that's not what 230 is all about. Courts have made it clear that where a company plays a large role in the creation of content, like image or text generation, that is not to be protected by Section 230. So that's a good rule that shows courts are able to pick up on some of the changes in terms of the technologies that are available now and take the principles of 230, the core principles that we had, and apply them to new technologies. I like it because it's reasonable and it's tethered towards the promotion of individual speech and expression and innovation. And those three kind of values Jennifer, those are what I started talking about when we began your discussions here at the Fireside Chat. I think it's fair to think about it, once again, because, individual speech and the First Amendment expression, and particularly innovation, because we've got to figure out how to compete against China and compete against people all over the globe. I still think 230 is right for the times.
Kind of to build on that and to wrap up our conversation with you, if you could go back to 1996 as 2026 Senator Wyden and talk to 1996 Representative Wyden, what do you think he would be most surprised about with how the internet has evolved and the role Section 230 had played? What do you think he would have been most excited about with the way the internet has evolved and the role Section 230 has played?
I think that I'd tell them, folks, one of the big things that we didn't do, we really didn't look at privacy, and we really didn't look at some of the data issues. Surveillance was not the big topic, then, and we've made big changes there. So I'd probably tell our friends, just remember that the big guys can always take care of themselves. That is never an issue, not in politics, not in communications. And by the way, the biggest single change in the last couple of years, and I don't want to get real, political, is that between Trump 1 and Trump 2, we saw the concentration of so much media in these hands of people who are really wealthy. So what we want to do is what Chris and I set out to do back in 1996, is to make sure that we said that at the end of the day, we wanted the little guy, the person without clout and political action committees and all this kind of political, might, that we would have voices for opportunities for the voices of people who were just innovators and had modest resources.
I can't help but think about how much Section 230 plays a role in our ability to even have this conversation with you virtually, in the ways that we have taken questions from online audience during today's event. I just wanted to give you an opportunity to offer any reflections you might have on the 30th anniversary of this law.
I thought that we were going to have something that would be helpful. I thought it would make a difference. But I think Chris would probably tell you the same thing, is I don't think we ever expected that it would play such a big role and be so prominent, and particularly be so central to the typical user. The typical user basically isn't somebody who's glorified and you don't see them on the cover of People magazine or some such thing, but their voice is so important. And I'm so glad that we were not only able to preserve it, but I think we enhanced the voice of the regular user. And that's why we want to keep those First Amendment rights protected.
And we thank you for your work, both on Section 230 at the time, as well as your continued work on online speech and internet policy today. Please join me in thanking Senator Wyden for his time.
Well, and also before we wrap up, Jennifer, let me just say one of the first calls we make when an important issue comes up in the tech space is to Cato. And you all have been there again and again and again. And we don't, that's the last point I'll make. We don't go into these things, and maybe I touched once on something political. We don't go into these issues talking about blue and red. We talk about the First Amendment. We talk about innovation. We talk about people who don't have clout and power. That's what it ought to be. And I look forward to talking with Cato often in the days ahead. And big thanks to the crowd assembled today.
Thank you so much, Senator Wyden. We very excitingly just missed having, I was very disappointed. We almost had exactly 230 RSVPs in person, but I was joking we needed to find a few more so that we could say we had 230 at 2:30. But we have also many people tuned in online, something that's possible thanks to laws like Section 230. So thank you once again. We know your time is very in high demand, so we very much appreciate you spending some of it with us here at Cato and with our audience today.
It's a great afternoon. Thanks.
Thank you. We will now take approximately a 1-hour break for lunch. Please join us back at 1 p.m. to restart with our second panel on Section 230's present, the current debates and challenges regarding Section 230, which will be moderated by my colleague David and Sarah, a fellow for free expression and technology here at the Cato Institute. For those of you joining us in person, lunch will be served on the second floor in the George M. Yeager Conference Center. We look forward to seeing everyone back at 1 p.m.
Well, I want to welcome everyone back from lunch here at the Cato Institute, as well as those who are joining us again online for this next panel to talk about Section 230 in the present. My name is David and Sarah, and I'm a fellow for free expression and technology here at the Cato Institute. And if you're interested, I just published a new policy analysis on the topic of Section 230. If after all of this today, you still haven't got enough of Section 230. Today, we've got a great panel lined up to discuss the importance of Section 230 today for both platforms and for users. We're also going to get to talk about some of the challenges and critiques facing Section 230 and how we might address some of those concerns. At the start, I just want to also note that as an audience, we will be taking questions at the end, but those of you who are viewing online can submit your questions via the event webpage, Facebook, YouTube, or X. But without further ado, let me get to our panel. First, immediately to my right, we have Ari Cohn. He's the lead counsel for tech policy at the Foundation for Individual Rights and Expression, or FIRE. A graduate of Cornell Law, Ari is a nationally recognized expert in First Amendment law, defamation, and Section 230. Ari has testified before Congress on these issues and advocates before legislators, regulators, and the courts to defend the open internet and digital civil liberties. After that, we have Ashkan Kazarian, who's a senior legal fellow at the Future of Free Speech at Vanderbilt University. A graduate of Moscow State University and Yale Law School, Ashkan leads the initiatives to protect free expression and shape policies that uphold the First Amendment in the digital age. Prior to joining Future of Free Speech, Ash was the lead for North and Latin America on content regulation team at Meta, where she also served as the company's lead on Section 230. That's where I actually first met Ash. And then to her right, we have Billy Easley. Billy is a lead public policy manager at Reddit, a graduate of UVA Law. Billy has spent over a decade working in government and policy research. Prior to joining Reddit, he was a senior policy analyst at the Americans for Prosperity, a legislative specialist for the U.S. Sentencing Commission, and counsel for Senator Rand Paul. And then finally, we have Gary Shapiro, the executive chair and CEO of the Consumer Technology Association. As the head of CTA, Gary represents over 1,300 technology companies and produces the annual Consumer Electronics Show. A graduate of Georgetown Law, Gary has spent the past 30 years working to advance policies that empower entrepreneurs and unlock technological innovation, earning him recognition as one of the Hill's top lobbyists and the prestigious French Legion of Honor Award. So with those introductions out of the way, those prestigious honors discussed, we had a great discussion this morning about what Section 230 did, its history, what it did in the past. But I just want to sort of level set. What is Section 230 doing for platforms and for users today? And I guess I'll go first to you, Billy, as someone here from a platform.
For platforms, Section 230 broadly does two things. First of all, it protects us from liability when the issue is related to content created by another. That's C1. And second of all, it allows us to enforce our rules. That's usually seen under C2. On Reddit, you're not allowed to dox people. You're not allowed to harass people. You're not allowed to target people based on their identity. That's reflective of 7 of our rules that we applied throughout the site universally, no matter what community you're a part of. We're able to identify that kind of behavior, take it down, remove it, because of the protections created by Section 230. But what I think isn't usually contained in this discussion, and which I'm glad that Senator Ron Wyden before the break mentioned, is the impact that Section 230 has on users, especially for Reddit, for our volunteer moderators, the secret sauce of our platform. When a volunteer moderator decides to create a community related to Game of Thrones or their favorite sports team, or a sensitive community, right? Like a veteran who's having difficulty transitioning back into civilian life, or a parent who's having difficulty connecting with their child. They're able to create rules that fit the vibe and ethos of those communities because of the flexibility that Section 230 creates. So for us, the way that I sort of sell it is that CDA 230 lets Reddit be Reddit. It allows us to enforce our rules, and it allows our users to find, create, and moderate the communities that they care about.
I think there's a particular lesson that we can take out of this moment in history. I'm not sure if my microphone is on, but okay, great. So we're in a time where the Attorney General of the United States and the Secretary of Homeland Security are getting on national TV and talking about how things like posting the name of a federal agent who carries a badge and a gun on behalf of the government that we pay them for, posting their name is illegal or is quote unquote doxing if you strip that word of any reasonable definition. And they have convinced some social media platforms and app stores to remove groups that track or discuss ICE operations. And FIRE is representing some of those people in lawsuits. But ostensibly, what Section 230 can do for both platforms and users is allow that kind of speech to be published, and the platforms have a way to push back when somebody comes knocking and says, you've just doxed a federal agent by posting their name. The platform can say, no, not every platform does it. We've seen some failures in Backbone, but at least it's there for the platforms that are willing to avail themselves of it.
I think often people confuse when we say Section 230 is for user speech with Section 230 is here for you to always say anything you want forever. And only everyone else is allowed to say what you think is right. But the world outside of our own self exists. And while Section 230 gives platforms an ability to moderate however they see fit, they do create these spaces for users to be able to connect. Without Section 230, they would be erring always on the side of, oh, we wouldn't want to get involved in X, Y, or Z. And it's not even things that some people might think are controversial, because it's not controversial to them, but it's controversial to someone else. So for example, the Olympics. Everyone's like, let's keep the politics out of the Olympics. But everything surrounding, our world in general, but also sport is political. And both sides of any debate surrounding, let's say, a men's hockey team would be probably upset if Section 230 didn't exist, because the other side would have sued platforms to get some of the speech they would say was harassment or hateful speech off the platform, because they would consider some of the things I've seen I would consider harmful on both sides of this debate. So yeah, I think it's important to remember that it is for user speech, but that doesn't equal all the speech you want.
I was just listening. It's great. No, we're all Americans here, I believe, and even if you're not, we are in the United States. And to me, what distinguishes the U.S. from most other countries is that we are based on a concept of liberty. And in fact, the Bill of Rights, the very First Amendment, at the very top, was a freedom of speech. And to me, Section 230 is the First Amendment for the digital age. It allows us to speak and be heard, but significantly from a business perspective, it also allows new businesses to be created. It allows smaller companies to come in without fear of litigation or, you can't stop someone from making threats, but Section 230 it's also like the First Amendment in that it's short, it's written clearly, and it's withstood the test of time. And here we are to celebrate it in part at this conference. I just want to note that the last time you had a celebration for 230 was 5 years ago, and then you shut down for several months for COVID. So let's hope that's not starting something or a trend. But I think we can celebrate 230 and recognize that what makes America great is our diversity of viewpoints and our willingness to have them. I think, though, let's be honest, we are in a troubled time. We have a leader of the country who clearly has done some good things, but he's not very nice in terms of how he approaches people, and there's a culture that's developed which is unlike anything we've ever known before. He's a unique president, and he's the role model for our kids and for anyone else who wants to express an opinion. And there is something called civil society, and there is a collision that's starting to occur, and that's why there's so many proposals to limit 230 between civility and what binds us as a country, and the fact that Section 230 really gives an equal platform to everyone, which of course the First Amendment does. But the First Amendment was kind of aimed at like people on soapboxes and the primitive newspapers. This is aimed at electronic transmissions which could go viral and really state that comment. I forgot who said it, someone will point it out. A lie could go around the world in a second and the truth will take several weeks or something like that. And we have to deal with that. And this is a great celebration, but let's be realistic. People are trying to erode 230 because they have some legitimate, heartfelt and human concerns about their children, about sex trafficking, about the fact that there's bias in limited media, like broadcast media. There is all these things, and I don't think we should illegitimize the humanity of those concerns.
Indeed. In fact, I want to spend some time talking about those concerns that people raise. Like one of the ones it's been sort of alluded to is that Section 230 protects the big guys. It's a common refrain that Section 230 is for big tech. But I've heard from the prior panel and from this panel, Section 230's one of its greatest roles is in protecting the speech of allowing users to have speech, and the role it plays in protecting new upstart companies. Can the panel speak to its importance in that way?
I want to be very quick and short and say that if you say that Section 230 protects big tech, I want you to say in the next sentence, the First Amendment is here to protect only Rupert Murdoch. And that's where your logic should end. Section 230, while applies to big platforms, and I think it should, because big platforms, well, even if they had all the resources to fight each fight in court, they're not going to do it because it doesn't. I believe Eric Goldman was talking about it in the first panel. It's not rational for them to do so. It protects small firms, it protects middle-sized companies. Engine.org has done some great research into how much it would cost to get these cases thrown out on the basis of the First Amendment, but how much it would cost them in litigation. And I believe the numbers are between $40,000 and $100,000. 40K or 100K. Sorry, I'm bad at math, that's why I'm a lawyer. There we go. So yeah, math is real, numbers are real, and that's where we would go.
I think to continue on with something that Billy said earlier, when he was talking about the moderators, you also, when you look at the way other platforms are structured, and again, I'm going to kind of go back to the Facebook groups about ICE, the people who create those groups are the people who create groups, say, there's a group that has chapters called Are We Dating the Same Guy that talks about, the toxic dating behaviors of local men, which, whatever, okay. But, if you create that group, you have Section 230 immunity for the people who join the group for the things that they post in it. So it enables not just the communities, but the communities within the communities. And on top of that, if you want to go back, a step past that, is if I, repost something that David has written to be defamatory because he's a big jerk like that, I am not responsible for what David posted, even if I reposted it, unless I, added something to it. If I just, do a naked repost or forward his email or something, I'm protected too. So it protects users, not just user speech vis-a-vis the company, but from the mistakes that we all make as human beings sometimes.
This was about 6 years ago, but didn't President Trump use 230 to protect himself from something he reposted on Twitter?
He most certainly did.
Just putting that out there.
I want to hop on something that Gary said a minute ago, which is about American values, right? On free speech, First Amendment values. I always viewed Section 230 as being reflective of American values on free speech and debate, right? And it's a principled approach. Look at the statute. It does not say, oh, if you are a big enough company, you are protected. It protects companies all the way down the internet stack, right? That doesn't just mean mid-sized platforms, large platforms, or platforms at all. It means domain registrars, right? Companies that host content, essential infrastructure internet companies, right? This created a solid foundation for the American internet that has had a huge effect on free speech and on competition generally. Something that I point out to people that I think most folks don't recognize is that libraries are specifically mentioned and protected under Section 230. And The worst thing that's happened to 230 in my mind has been it's been framed in these political debates that only look at one or two companies instead of recognizing the impact it has on the entire stack of the internet.
So for those of you online and in person who have been following Punch the Monkey, I've been really connecting with that story. And I do want to say that the analogy I've been making, and I'm going to keep making until it's a thing, I'm going to make fetch happen, is that Section 230 to me sometimes feels like that monkey. Like the other monkeys are punching it over something it didn't deserve. People are mad at the internet for many reasons. I mean, I'm mad at the internet every day. And if you look at congressional hearings or the debates around Section 230, often it's not even about the speech. It's privacy or the size of the companies or the fact that Mark Zuckerberg looks weird that day. People get mad and then they blame 230 and they want to do something with 230 to hurt whoever made them like angry on the internet. What people often also forget about the internet is that it's just a mirror to our society. Like often if you see something online, it's the person behind it that is being reflected to you. And
So you're saying it's a two-way mirror.
It is a two-way mirror, yes, but it's connecting us to good people, but it's also connecting us to bad people and bad thoughts and bad ideas, and it's a tool in itself, and I don't think we should be taking it out on Section 230 because we're mad at the tool.
There's also, increasing attention being paid to the rather draconian foreign internet regulations, and while we are still kind of in the nascent stages of how they're going to try enforcing that, maybe against platforms or websites that don't have assets in Europe to go after, Section 230 could end up being something of a bulwark towards enforcement efforts in American courts, which we should not allow them to be enforced anyways as violations of the First Amendment. But that also could be a useful tool in that sense. And the more attention that is paid to the overseas censorship and that tries to bring itself to American shores, I think the more people should wake up and realize that we need all the tools we can get.
Can I piggyback on that for a second?
I was done.
About a year and a half ago, we had the situation in Brazil with X and Elon Musk, where Supreme Court Justice of Brazil, who is self-appointed decider of what speech is allowed and what's not, and that's their own constitutional system that I'm not here to comment on, had made all these kind of basically executive decisions to shut down, not allow X to be there. Then he moved on to trying to seize Starlink and other. It was all very much grounded in the fact that he was not happy with what kind of speech was allowed on the platform in Brazil, and he was using this to do that. And that is unfortunate. It was also funny because I think the opening NFL game that year was in Brazil, and all the sports reporters had to text their wives to post on Twitter as that was happening, which I also found fascinating way for them to reach back to America in Section 230 to share sports news with us.
Could I get back to your question for a second?
Sorry.
So the question was about big companies, small companies. And I will say that we here, as we are a membership organization, I am paid to represent 1,300 tech companies in an industry. And we hear from smaller companies that they are hurt by 230. We hear from retailers that their competitors post clearly false things about them. And I know you could figure it out maybe somehow who actually posted it and bring a defamation suit. You could ask it to be taken down. Or maybe some entity will be created, or Cato itself could come up with a way of ranking and dealing with companies that can deal with the fact that there is false information put on their websites. I was talking to my wife last night, who's an eye surgeon. She's a retina surgeon. And she was very strong when she heard what I was talking about. She said, there's someone on this Dr. Ratings website that posted on about the lousy bunion, how I ruined their foot by taking off their bunion. Well, I've said, I've never touched a foot in my life as a doctor. And I have tried to get that website. I got a lousy rating and a lousy comment about it. And there's nothing I can do other than sue the website itself, which she'd probably lose on, and it's fundamentally untrue. And looking at small versus big, I would say like some of the big companies like Google, for example, they have a way of responding to something negative. But a lot of the other websites may not, and they hurt businesses, they hurt reputation. And what I'm saying is I love 230, but we can't just ignore the harm that people are individually feeling. And we have to come up with ways, and I prefer private sector ways and ratings and things like that, of dealing with the fact that there should be a way of dealing with it. And we had an issue of privacy that came up under President Obama about the devices that we wear. We sat down all the companies in a room, Apple and BlackBerry and Samsung and Google, and they agreed that here's what we should do because we're ethical, moral American companies. Wasn't an antitrust violation. It was obvious stuff, simple language. You know, you could withdraw. You can't sell people's information. You can't use it in any way without their permission, and it has to be affirmative. So and since then, there's no talk about that on a device basis. I mean, there's talk about a lot of other stuff in privacy, but to me, patent trolls are an issue. They put smaller companies out of business. There's no 230 protection, if you will, for the small companies that are just trying out and someone buys patents and just goes after them, they have to settle. So we have a lot of issues in this country. 230 makes me very comfortable, but I wish there was a way, private or otherwise, that we could address legitimate concerns that people have, and they are legitimate concerns. And failure to recognize them in this cheerleading session, I have to admit, it's getting a little to me. It's like, this isn't all good, folks. Just the way the First Amendment has all these exceptions, Near versus Minnesota, things during wartime, you can't do troop announcements and tell where the ships are. There's First Amendment little corridors in the public. Things evolve over time to provide exceptions to protect the greater good. And when I heard this morning talk about, like, it's okay to dox a judge and put it out there. Is it okay to put the judge's address out there, home address? At what point do you draw a line where the interest of public safety of the guardians of our legal system are more or less important than this ability to say, I feel this judge should be taken care of?
I want to validate what Gary was saying, but also mention two things. First is we have some data about DMCA, which is a system that deals with copyright disputes and issues, that shows that the takedown system that has been created is being abused by those who have more money and more power to take down things. And I'm going to talk about actually Reddit here, and this is all alleged. But I have noticed as a millennial woman that on Reddit, any forums or subreddits that talk about the influencer Alex Earl get taken down very fast. And allegedly, in the sphere, it has been discussed that they're probably using very good lawyers and a combination of DMCA takedowns, because usually when the discussion happens, they attach videos or pictures. And DMCA, and Reddit doesn't have time to deal with this or resources with each of those. So again, this is all, I'm looking from the outside in. And that's just someone who has a lot of money who can do that and protect their reputation and stay out of being discussed by people. So that's one. I think we as a society, Section 230 is now 30, very much millennial, very much, I would still say, young adult. And we are not as a society caught up with the volume and change that the internet created for us. I think we need to be more focused on teaching from very early on, something that I've been calling and other people, digital citizenship. How do you exist in the online world? How do you assess information that you're receiving? How do you check sources? How do you protect yourself, your privacy? And how do you behave online? I think that's something that should be taught instead of whatever kids are learning sometimes in 5th grade. And I think as we as a society catch up with this digital citizenship kind of idea, I think it will also eliminate a lot of the issues that exist when people, both of my parents are professors, and it's really funny to compare what people have posted about my mom versus my dad. You can go online and check it out. And I would disagree with some of those things. Sorry, Mom. But I think, maybe if people had learned and had a little more maturity when it came to operating in the online world, we as a society would be doing better. And then we wouldn't have to have government deciding what speech is okay and which doctor is doing eye surgery and which doctor is cutting off your bunions.
So Reddit was invoked. So I will.
Yes,
I'm
go ahead.
I'm going to double
the next one, but yes.
First of all, if you want me to talk about DMCA abuse, I can do that. That's a whole nother panel. But I do think that it's important to note that there's a parallel here. I think in a world without 230, it becomes much easier to simply sue and say, all right, well, okay, are we going to defend every piece of speech here? Or does the incentive to take down content and remove it to save the company it drives everything out of whack? I do want to note, to Gary's point, that look, we can put down the pom-poms here for a little bit in our cheerleading session, as you put it. I think that the policy trade-offs of having 230 are worth it generally to our users and to competition angles for allowing smaller companies and mid-sized companies to compete. But there are serious issues here, and I suspect we'll get to them as well. But I just wanted to note that.
I'd say also there are ways. I mean, for instance, if somebody is posting a judge's address with the intent to threaten them, and it's a constitutionally prescribable threat, Section 230 doesn't immunize them from prosecution under federal criminal law. If there is speech that could be made criminal, that rises to that level that the First Amendment wouldn't protect it, we can pass laws about that. There are
What
ways.
if they just have the address of a judge? Is that okay?
It depends on the context. It's all context.
Any context.
Well, so for example, I believe there was some investigations that had looked into public officials because publicly available information about their address was who had all of these like really expensive houses they could have not had, and then it turned into a corruption investigation. Because I think we as a public also should know things about public officials and hold them responsible when they're, I don't know, like flying business class to Turkey.
Right, posting a judge's, like the value of a judge's house, or say posting the picture of an envelope that got delivered to my house by accident and it turns out the addressee is a judge could be totally innocent, whereas posting it in response to a comment that says all judges should die could be different. It's all context dependent. That's the problem.
And on that note, I want to bring us to some of the concerns that people have raised, and specifically right now we are circling around this idea that probably one of the most common objections that we hear about Section 230 is that it means that companies are not responsible when they allow harmful speech. This idea that because Section 230 exists, harmful speech proliferates. So I want to just continue that conversation. How do people think that we can address? Does Section 230 just allow the Wild West, or is that wrong? How do we think about that criticism of Section 230 allowing harmful speech?
Well, it already has exceptions for very harmful speech. Obviously, federal criminal law, but also, look, there's a societal view, which I think is bipartisan, that child pornography is fundamentally wrong and must be banned. When you get children involved, a lot of the rules go out of the way, even the First Amendment in some ways. So there are already mechanisms to deal with it. One of the questions on the table, though, is whether there should be additional narrowly crafted exceptions.
I actually don't think that's the question on the table, because you see repeal laws being introduced in Congress related to CDA 230. In fact, we have supported through our trade association, InternetWorks, which is composed of over 20 small to mid-sized companies, we've supported narrowly tailored bills that we think go to the harms that are impacting kids and everyday people online. The Report Act, which enables us to hold more content related to child sexual material for longer to aid investigations. The Take It Down Act, which passed last year. The real problem here, in my view, is that CDA 230 has become this sort of hostage that people will point to as the real sort of root of the cause of harms, when instead it would be much more effective if businesses, the government, civil society could come together and say, okay, if the issue is coercing children to do bad things online, or CSAM or other things, what are the specific things we can pass that respond to that, instead of just simply saying, let's throw CDA 230 out altogether.
Yeah, and with all due respect, the Take It Down Act is a travesty.
I know you feel that.
Regardless, most people actually will just say up front, if you present me with a narrowly constructed carve-out, that would be something I would be willing to consider. Like, there are very few people who are just flat out say, I would refuse to consider, any changes. But, the issue is, rather than really being about whatever harms people say they are trying to combat, it's really just it's a partisan cudgel, and it's aimed exclusively at giving whoever is, whichever party is proposing it, a lever to pull on which to, either get content they like to stay up, or coerce platforms into taking stuff down they don't like, even if it has nothing to do with the harms related. The problem is that all of these exclusions that people have come up with, and proposed for Section 230 are all easily weaponizable as tools of job owning, and we know that's how they be used because that's how they are always used. So if perhaps the people in power demonstrate that they can be responsible adults and not use well-intentioned ideas to censor whatever speech they don't like, maybe these conversations would be easier. But right now, here we are, right?
I'm so sorry about this. I have an example.
Oh, no.
You don't know what I'm going to say.
I know exactly what you're going to say.
Your former boss, Senator Rand Paul, in this libertarian power, I'm sorry to say this, he's been a big proponent on 230 for like years and years. And then recently he published an op-ed that said, this woman had on YouTube alleged that I was involved, there's something with Venezuela.
YouTube took it down.
The woman took it down, but
yeah,
he said, I, very important person, emailed YouTube, and they didn't take it down immediately. So now I have changed my opinion on Section 230, and we should amend it. And I think that's such a great example of how your feelings and good policy don't equal each other.
So what should he have done differently?
What he should have done differently.
Well, he waited 5 minutes and it happened, so
Yeah, so first of all, that information was taken down. Second of all, I wonder, would he call himself a libertarian?
Yes.
Okay, but as a libertarian, I would figure that he has strong, positive feelings about the First Amendment, and he would assume that what this woman was saying was protected by the First Amendment. I have not seen the video, so I don't know, because again, it was taken down pretty fast. But more speech is the answer usually, counter speech, and facts are still facts, and he could have defended himself. And honestly, I think there was, Mike Masnick is here, there's some Streisand effect to that, of him talking about this so much that now we all know, some person randomly on YouTube alleged that he dealt with Venezuela, and now I've said Venezuela 4 times.
It's like the member of Congress that held the press conference to deny that he was the stupidest member of Congress.
And this goes to a follow-up I want to point out, which is, I think it came up maybe in the prior panel, but and Ash, I think you've been alluding to this idea that sometimes we're talking about, we're dealing with illegalities, with clear crimes, but sometimes we're dealing with things where people are just frustrated with the free speech rights of others, content that would be protected under the First Amendment, like if you went and said it at a town hall meeting or if you put it in the local newspaper, it would be protected speech, but they seem to be upset at 230 because the company won't take it down fast enough or something.
I want to talk
Or
about...
at all.
Or at all.
Yeah, I want to talk about harmful, right? We've said harmful a few times too. No one online will see the audience, so please be as free as you can. Raise your hand if you think that content creators that talk about body positivity and eating whatever you want and living your life and enjoying it are harmful to young women. Okay, now raise your hand if you think that the fitness influencers, or let's say Lily Collins, who, just by the way she talks about food, or fitness influencers who talk about counting your macros and working out this amount of times and never eating anything that has been ever processed are harmful to young women. Okay. This is an interesting also social experiment, but just for you online, we had some disagreement. By the way, I think both are harmful to young women. And so who is gonna decide? Do you want the platform to decide? Do you want the government to decide what is harmful to young women? Or should we, as a society, maybe figure it out ourselves? I'm a millennial woman who grew up originally without the internet, but the People's Magazine was telling me that Jessica Simpson being size 6 was very overweight and fat. And so I think some of these issues of what's harmful speech and what's not have been the same issues we've been experiencing, maybe now on a greater scale because we have this two-way mirror. But they're still there, and we as a society need to stop blaming Section 230 for everything that's wrong.
And I think the question itself actually points directly to something Billy said in his very first answer, which is that the upshot of Section 230 going away is that it really doesn't even matter because all people are going to do is just file lawsuit after lawsuit after lawsuit after lawsuit, and then the incentive structure goes heavily towards just the second somebody complains, take it down because it costs too much and it's annoying to deal with. And that's the whole problem is that, it is Section 230 is a bulwark against, the the social media equivalent, complaint equivalent of SLAPs, strategic lawsuits against public participation. So, you know, without that, all you're going to do is not necessarily have rules that make this content not allowed, but de facto rules set by people who can pay lawyers to file lawsuits.
Our view at Reddit is that the solution here isn't to have just sort of this like universal rule where we come in and we say like, well, actually, we decide that, you know, the influencers are bad, right? Instead, we decide, okay, well, we have our volunteer moderators. What communities do you want to create? Do you want to create a community that says, I don't like Lily Collins? You can do that. If you want to have a community that says, I'm a big fan of hers, you can do that, right? We're not going to be able to sort of decide these questions as companies all the time. I think the better way to do it, the more democratic way, is to say, as long as you are abiding within our behavioral rules, have at it. Have the discussions that you want to have the different viewpoints that you want to have. And this kind of goes to some of the concerns that I have with some of the existing legislation out there, like the Kids Online Safety Act, which try to short circuit that sort of discussion and instead sort of say, well, we have buckets of content that we just know, flat out, have to be, are deemed harmful, but don't take into the context of, don't recognize the contextual differences when those discussions happen.
And I also just want to confirm, Reddit has both sides of a viewpoint, and Lily Collins currently
And Ash is the moderator of both of them.
And I also love Lily Collins, and she just got casted as Aubrey Hepburn. I am so sorry. That was just an example because I had seen it online.
Am I the only person who doesn't know who Lily Collins is?
I have no idea.
I don't know.
Emily in Paris? Emily in Paris? Emily in Paris.
Emily in
Okay.
Paris.
I don't know what that is either.
On that note, though, I want, or not on that note, really, I want to spend some time quickly opening up. We've got quite a few legal minds on the panel here. There have been court cases, current sort of court cases around Section 230 regarding things like, or in the near past, things like product design, saying that Section 230 doesn't apply because the product has been designed poorly, or it was mentioned in the earlier panel, TikTok v. Anderson, the idea that somehow using an algorithm strips you of your Section 230 protection. I was hoping the panel would discuss some of these current matters.
I have opinions.
I know you have opinions.
Okay, so Anderson versus TikTok, we'll start with that one. It is an opinion that makes no sense if you use traditional logic. It is a decision where the Third Circuit decided that because Moody versus NetChoice had held that a platform's content moderation is First Amendment protected, therefore it must be first-party speech and not information provided by another information content provider under Section 230, which doesn't really make any sense because if you are facing publisher liability, you have, by definition, engaged in First Amendment first-party speech. There is no way to face publisher liability without doing that. It is obvious you also wouldn't need protection from publisher liability if you weren't doing First Amendment or first-person publisher things. That's the whole reason Section 230 was necessary.
Anderson was suing TikTok for a video that, at least I think there was confirmation that one video was shown of a blackout challenge, and someone who was very underage had seen it and unfortunately had passed away. And then the court had decided that was TikTok's speech, even though it was not speech that TikTok created. Sorry, continue.
Yeah, so it's just, it doesn't make sense. The court basically said, well, you did this thing that Section 230 protects you for doing, and therefore Section 230 doesn't apply. Okay, so that's Anderson versus TikTok. Nonsense opinion that a 1L could probably have written better. Then you have the products cases, the things like addiction, and you have things like infinite scroll and ephemeral content and what have you. But what nobody can answer, at least on the state's or plaintiff's side, is what are you addicting the kids to doing? And that is viewing more content. You can't, if every video on YouTube was in an infinite scrolling feed of auto-playing videos, beige paint drying on a wall, I'm sorry, nobody's getting addicted to that. And if they are, they're not going to be harmed by it in the ways that they're claiming kids are being harmed. The only harm that is being caused is because there is certain content that is doing certain things that they don't like. And you can see this, they admit this in the court filings when they say it invites social comparison. How can you have social comparison without the very specific types of content that allow you to compare your life to somebody else's? It is always about the content. They admit it's about the content, and still we are in these endless nonsense conversations about whether or not this is about third-party content or this fictitious category called design features.
And there are still, there were cases, for example, Lemon v. Snap, where the court had decided that a speed filter that teenagers were using to measure
Which could have caused harm independently, no matter if content was created or not.
And then they were driving fast and they crashed and they all unfortunately passed. That wouldn't be protected by Section 230. We keep talking about Section 230 as, and by we I mean like the ether, as if it's like this untouchable thing, but there are like court cases that they have, you should all read Eric Goldman's blog, and he talks about a lot of the cases where that's not the case. And another thing about TikTok v. Anderson is that that's now just like the Third Circuit. Now we have
sitting there.
Yeah, there's a court split. Supreme Court should have addressed it in Gonzalez v. Google. There are all these things. You can read our Lord and Savior Jennifer Huddleston's paper that just came out on the issue.
Wow,
or if you want to dumb down, I also had a paper about that called I Built This Algo Brick by Brick. Also talks about it less like legalese, but hers than mine. If you want more on this topic, sorry for the plug. But I just want to say that when it comes to algorithms, I feel like this is like the new horizon of like fights about Section 230. People have moved on from like Section 230, and now they're like, no, but algorithms are different. And because of that, we're gonna like rejig this whole thing. But algorithms, and the Supreme Court has like said this, are just tools that platforms are using to exercise their editorial discretion. Same way newspaper would decide what to put on its front page in big letters, or same way like anyone would, emphasize one thing as the speaker or the publisher of a platform, whatever, doesn't matter in this context. Just want to say that. So it's an editorial function that now people are treating as like their new way in. And I think TikTok v. Anderson had like tried to open the floodgates, which is why you should read the papers and engage in this. But yeah, I feel like that's like another fight that's waiting to happen.
So I think Ari did an exceptional job already talking about why I think TikTok v. Anderson is just a bad case. So let's take the legal stuff, put it in a box for a second here. The issue, we'll return it, we'll open it back up. Algorithms aren't evil, right? They're a tool, right?
People are evil.
They're a tool that can be used in positive or negative ways. And you can tell in these lawsuits and in some of the policy discussions that there's this sort of premise starting that like, no, the algorithm is like, all right, we couldn't get it through CDA 230. Maybe the algorithm is the issue. If we could just attack that legally or through policy. And something I always remind people, like, we use algorithms at Reddit to identify bots, to identify foreign information campaigns, to identify policy violating content so that we can evaluate it, much more at scale than we could before and remove it, right? If people choose to, you don't have to. We allow choice on our platform. You can use algorithms to recommend content that we think you will like because you subscribe to the NFL subreddit. Maybe you want to subscribe to America's team, the Dallas Cowboys subreddit as well.
But also, if you display posts chronologically, that is performed by algorithm.
Exactly. So I think I think this is going to, for the same reasons that you brought up, Ari, I think this is going to hit the same brick wall of the First Amendment too. But I think we might disagree on one small thing, which is I actually don't mind the discussion about products and addictive feeds as much as I feel some of my peers do, because at least it's tied to a real discussion about what kind of internet do we want to have and what kind of problematic issues that people experience.
But do we want an internet created by the plaintiff's bar? I sure don't. The idea of being addicted to like more speech is very troubling to me from a First Amendment.
Do you think children's television should be regulated?
I don't think that children's television should be regulated.
It is under the First Amendment.
To the extent where they can tell the the creators, oh, well, you can't use this color or end on a cliffhanger because kids will want to watch the next episode, because that's what we're talking about.
But they do cover product placement and cost.
Yeah, but product placements
that's what you were just talking about.
That's not the analogy. Like, that's.
I just think that at least then I can have an honest discussion of like, okay, so what is it that you're mad about? Is it infinite scroll? Okay, well, tell me why you actually think that's a bad thing.
Let me
right?
put it a different way. How many people, by a show of hands, have been on the internet and you go down a rabbit hole and you look up, it's 15, 30 minutes, your life is gone because you have been fed things that you have clicked on and then you get more of it and then you wake up and you realize, I want that time back. Anybody by a show of hands? Am I the only one?
Can I do a show of hands of how many times you like kept watching Netflix even though you should go to bed?
Or went to one more store at the mall.
Yep.
Okay.
So, I want to take a moment.
But my point in that is that there are certain elements of society which deserve protection. I don't think any of us do. We're adults. Kids should get protection.
I want to, since we have a great conversation, I know we could go on like this for a long time. I do want to address one of the other criticisms that people often aim at Section 230, which is that it allows, as opposed to too little moderation, it's that Section 230 allows too biased moderation. So what are people's thoughts about that?
My thought is that
criticism?
the free market is a wonderful thing, and you could choose. I would prefer that there would be a little disclosure, but like, hey, we're Fox, we're conservative, we're MSNBC. Everyone kind of knows that, but because websites are almost infinite at this point, you don't know what you're getting into, and then you just get more of it. But that should be voluntary, or it should be by other parties that are saying, look, we're editors in a way, this is what you're getting here. And at some point, you could talk about disclosures. And I don't think algorithms should be disclosed because it's, as you say, a lot of them are just like for getting around in life. But there is something in me that feels that if you're doing something in a way which is, let's say it's foreign countries are coming in that are hostile to us, and they're manipulating sites and doing things like that, I want to know that.
I couldn't have said it better myself, honestly.
Well, the thing about the argument that there is too much moderation is also that people actually don't agree on too much moderation of what, right? So this is where we get back to the free market question. But it's also, I think we, again, because we are selfish creatures, forget how much content there is out there. There are billions of pieces of content that go online. And a lot of this moderation that happens is pieces that like we don't see because they're spam or they're bots, or sometimes pieces that just those platforms don't want to have. And in the United States, we have a Supreme Court decision that says that platforms are private entities that can decide what to allow and what not to allow. And then previous panel talked about AOL, that is not like really a thing anymore. I think we're also seeing the cycle of that happen with platforms where maybe they're not as cool anymore. Maybe their moderation practices are not what the generation or the next generation wants. And we're seeing the shift already. We have seen the shift from Facebook to Instagram to TikTok to Discord and Reddit that has held strong throughout all the generations. And I think that's just the natural thing. And I'm not sure how you would regulate the over-moderation. I just know that often the over-moderation happens and then you feel like personally targeted.
Yeah, I mean, the over-moderation is just, that complaint is just this platform has a different view than me and I don't like it. And I mean, my answer to that is tough. There are plenty of platforms out there. You don't have the right for every social media platform to be the platform that you wish it was or that you wanted to build. There are options out there. We actually have a fairly diverse market of social media platforms, even though people say, oh, no, you can't be on Facebook anymore. I can't remember the last time I logged into Facebook in the first place. It's as Ash was saying, the evolution of social media has been one of meteoric rises and then dramatic drops off a cliff out of nowhere for a platform. MySpace, Friendster or whatever don't exist anymore. And the idea that, that a platform has rules that I don't like and therefore we should remove 230 so that I can force it to have the rules that I do like, is just lazy. It's lazy.
It also doesn't have, okay.
So Reddit was the First Amendment issues.
Reddit was sued under one of these laws that was passed in Texas. Texas and Florida both passed laws about viewpoint discrimination and political bias. And I think it's a fascinating example of how awry these sort of systems actually get impacted, right? Because we were sued in Texas. We wrote about it in our brief on the Gonzalez v. Google case as well, where we talked about someone on the Star Trek subreddit who sued a moderator because the moderator removed their post calling them a soy boy. Violating the Be Civil rule.
I was expecting it to be even dumber than that, but that's pretty dumb.
That's pretty dumb. And so they said, oh, this is viewpoint discrimination under the Texas law. I'm going to sue on this. You are silencing my speech, my right to insult you. And this is what's going to happen when we kind of try to put these sort of viewpoint discrimination frameworks in place. First of all, as the court, I think, pretty much basically has said, this does not comport with the First Amendment. It's also going to harm the ability for our volunteer moderators to do their work, which is also why they submitted their own brief against these laws as well.
I was going to actually ask a follow-up question about those four.
Sorry, I jumped
but
ahead,
you nailed it. I just want to remind the audience that we will soon be jumping to questions, and also those online. Again, you can still submit questions via the webpage, Facebook, YouTube, or X, and I've got a pad where I'll be looking for those. But just one more question. We've sort of talked about it actually a little bit, zooming back out to the policy debate about what we might want Congress to do. There have been, I think in the past 3 months, I've seen 3 bills to effectively kill Section 230. But we've had discussion of, well, are there other changes that we think would be good or that we could make to Section 230? Or is this just like a box that is not worth opening? It's too dangerous to open.
Could we get a whole new Congress?
Or are there changes that we could make that don't involve Section 230, but that we think would address some of the angst that maybe is improperly directed at Section 230?
I'll start. I also love how we keep talking about the box and legal issues in the box or Section 230 box. It feels like the Schrodinger's cat situation. Is Section 230 still alive? We'll check. I think one that I think is very straightforward is people are upset about some of the horrific crimes that happen online or CSAM spread. At the same time, if you look at the number that platforms are reporting to NCMEC, National Center for Missing and Exploited Children, and the amount of resources they have to investigate that, it's not even 10% that I believe they are. Stop Child Predators has numbers and research on this, that they're able to do. So why do we not give them money and resources to do that? Sesta FOSTA was mentioned on the first panel. Sesta FOSTA was not really used after it was passed by law enforcement, but what had happened had some consequences for a lot of sex workers, and they were more in danger. And also at the same time, a lot of the crime had moved from the platforms that would report the crime to the darknet. And if we talk about local law enforcement, and honestly even federal law enforcement, they don't have enough resources or experts to investigate there. So I think more resources for good guys to catch the bad guys is an easy answer. And I don't know why it's not the first thing to do. If we already,
it's hard.
Right? No, but if only 10% or less than 10% are the tips that are being investigated, why not at least make it 50, and then go from there? So that's one.
Well, it is a allocation of taxpayer resources that you're advocating for, and it's always easy to advocate for that because it's not our money, but it is our money.
It's my money. I pay taxes. I would rather that go to that instead of some of the things.
Well, I'm going to reiterate something I said before. I think there could be really, and there have been, and on a lot of issues, really substantial, productive conversations between industry and government, where government brings out the concerns that specific individuals and groups have about harms online. We respond to those, and instead, I kind of feel like Congress has decided, all right, well, we're just going to use whatever lever we have. We're going to use CDA 230 as a hostage to force you to do X, Y, Z. When instead, you could fund, NCMEC more. You could pass laws that focus on child safety. There's, I believe Senator Grassley from Iowa has the ECHO Act and the Sextortion Act focusing on the scourge of child extortion online, right? Like, I think those are pretty good bills that go to like an evolving thing that didn't exist 10 years ago online, but has become much more prolific, unfortunately, that industry and government can work on. That's the solution. Don't take the sledgehammer of 230 repeal when a scalpel will sort of suffice on these issues.
You just, sorry.
Go ahead.
I'll be very short. You just reminded me, so first of all, yeah, it is our taxpayer money, but isn't government's one of the first function is to protect us and keep us safe as a society? Like, I think taxpayer money should go towards that. Second is, there was something about over-moderation that I forgot to say that I just remembered, and it is, often we are having these conversations about one administration or another throughout the years that is collaborating with platforms and pressuring platforms, and also sometimes even threatening repeal or amendments of 230 if platforms don't moderate the way government wants them to. And I think that's so much more dangerous because government, unlike these platforms, can throw you into jail. So that was the second short thing.
But that's, you know, that also kind of goes back to your first point, which is that a lot of this stuff is criminal, and Section 230 already excludes federal criminal law, and if prosecutors had the wherewithal and maybe the motivation to actually prosecute a lot of these things and investigate these things, maybe it would be less of a problem. You know, I'll be blunt. You know, if I heard a good idea, I would consider it, but it's also, I'm not inclined to go out looking for ways to poke holes in Section 230 to fix problems that could be fixed without touching Section 230. You know, I'll tell you whether your idea is good or bad, but I'm not going to come up with new ones for you.
Who was the senator from West Virginia? Was it Markey?
No.
That's definitely not the person from West Virginia.
Sorry, there was a senator, oh no, that's not Markey, you're right.
Manchin.
Manchin. See, it was M.A. I skipped lunch today, I'm sorry guys. He had this bill fighting like drug sales online, and like his thing was like, oh, like people like sell drugs in Instagram DMs, so Section 230 should be amended so Instagram is held liable for two people selling drugs online. And like, that's like the second type, right? So there are two types of Section 230 reforms that I've seen. One is like sunset or repeal, and the other one is like these weird like carve-outs for whatever like his state, I guess, is going through.
Yeah. Well, I want to go back to the question and say, what should Congress do? Well, I think depending on the winds and how they flow, Congress will do something at some point. And the question is, do you want to do something first to try to help divert that and do something? And the whole, my career for 40 years is focused on new technologies coming in and people saying how terrible they are, and us and the incumbents, and they want to preserve themselves, and we're out there fighting for these new technologies. But generally, what we've tried to do is say, here are some potential things that could go wrong. Let's try to address them voluntarily. Let's try to have inter-industry agreements. Let's not go fight it out in Congress where you end up with the biggest lobbyist wins, because we lose then. Because we're the new guys that don't have the big PACs, even with all the tech companies and things like that. The big tech companies, on the other hand, are probably the most responsible in this area. They are trying so hard, and I count you as a big company, sorry. They try to do things which are responsive and I would say ethical, but not necessarily required by the law. And of course there's holes and there's gaps. So the question is, can you do things which just bring public awareness? Can you come up with a voluntary or maybe even a federally created rating system of different steps you could take and different levels you can go to that would give parents and locals and others, like if you're willing on a ratings website to have someone rebut something which is clearly false, that's a good thing. The challenge we face is Section 230 is great. But on the other hand, even with 230, there's a number of websites which don't allow comments at all because they just don't want to be accused of it. They don't want to do it. There's already a chilling effect out there just because of the court of public opinion and legal uncertainty, which still exists. Just hearing you discuss some of these cases boggles my mind. And there'll be always more cases. And I guess it's the Lawyers Relief Act, and you're all up here. That's great. You know, full employment. We want it. But I think that at some point we have to come up with more creative ways without saying Congress has to do something. And we need a better answer than just saying, I love the First Amendment, I love 230. Say, here are some societal harms. Are there other ways to address them without Congress getting involved? For example, in the product area, there's a whole bunch of agencies that do things, and they say you could have You could sell a car that gets lousy gas mileage. You just have to say it. You could, Energy Star is a great, you know the energy efficiency. Who doesn't want more information? Even from a Cato perspective, I think that's a good thing. More information allows consumer choice. And I think if we approach it that way, about information allowing consumer choice or parental responsibility, I think would be healthier.
Or if you even if you're like, if you want to go in the bare minimum of congressional involvement, it is something like congressionally funded education programs for parents to help keep their kids safe, to use the parental control tools that are already being offered by the platforms. You could empower parents a great deal by just teaching them how to parent in the modern age, and nobody's really doing that.
There are bills in House E&C on this, actually.
Terrific.
So I think that's, I actually think what's happening here is a lot of members of Congress recognize that the First Amendment is going to be a huge problem for these like broader frameworks, and understand that public education, working with the companies, even rating systems possibly, something that clearly signals that a standard is being met would generally
It would help. I just want to say something about parental controls, because parental controls are great in theory, but in practice, the kids know more than the parents about how to use them. The V-chip was something that Michael Petricone and I spent a lot of time fighting unsuccessfully. And what we said turned out to be true. If everybody is mandated to do something, it ends any discussion about competition among them. There's a proposal in Congress, every car must have an AM radio. I know it's crazy, but it is true, and it's going quickly. But one of the reasons not to do that is because then there's no competition. No one will even advertise that I have an AM radio, and the AM radio, the sinking industry will sink further in waste spectrum.
Two things. Kids also have First Amendment rights. Yes. And second one is something you said made me think. I want to say the quiet part out loud. Solutions that include studies and complicated structures and civil discourse and us being better as a human nation are not things that members of Congress put in their press release as they're running for re-election. Yeah. It's much easier to be the face of, I am taking on Elon Musk, or I'm taking on Mark Zuckerberg.
That's true.
And I think that's like the reality of it. And I think that's also why we've seen Congress not be that effective in many things.
On that note, we will move to our audience questions. Just a reminder, we'll be doing it both from online and from in person. We'll have microphones on both sides, so if you'll raise your hand, I'll call on you. I'm going to start with a question from online, then we'll go to our audience. I have a question from Melissa's asking about Russian trolls and bots. Are they okay, or can they be banned, and are they banned? What are thoughts about foreign trolls
I'm
and
Russian.
bots?
Can I talk about it?
But you're not a troll.
No, never.
Depends on the Reddit
You've never been in a
subreddit.
group chat with her.
Well, so I guess banned is the question of can we ban speech? The answer is the First Amendment says no, especially because you don't want the government, whoever is at the White House or whoever is in Congress, to decide who's a Russian bot and who is not. There's a very slippery slope, and I'm pretty sure there would be some members of Congress who would call me a Russian bot. And so I think that's number one. And the other one is there's also, I can never say it's like French. What's the Le Monde? No,
Le Monde.
The
newspaper.
The versus the Post Journal. There's basically a Supreme Court precedent that says that we here in America have the First Amendment right to receive Chinese propaganda because it's still speech, and we can, for our own, decide if we believe the Chinese propaganda and we don't. Postmaster General, there we go. So that's my answer.
At Reddit, we consider bot activity, coordinated bot activity, to be content manipulation. You're not being honest about who you are or where you're from, and we ban that kind of content, specifically because of that. We think people should be authentic when they're on Reddit. But people should be able to decide, platforms should be able to decide on their own. And clearly, there's a difference between the government deciding, okay, we are going to ban all bots that originate from a foreign entity, and a company decided to do that because of the impact that it has on their systems or on the quality of conversation.
It also depends on how you define a bot, because there could be something as simple as an autoresponder that keeps track of a price on Amazon or something that notifies you when it's a lower price, and people would say that's a useful bot.
There is all this reporting done that there is a farm somewhere in St. Petersburg where people are sitting behind a computer and
They have
posting.
cows.
They're like trolls, and they're posting and engaging in the discourse online, pretending to be someone else. I actually think a feature that X, had helped with that, where they just show where that account is located. Like you can see, like I've seen now people like trying to like engage in NFL debates, right?
Yes.
That you and I are having.
the
But then I look and I'm like, you know nothing about football. I'm sorry. You're just trying to like get likes, or you're trying to get so more, you know.
A great transparency measure, yeah.
Yeah, I think that was a great transparency measure, but it helped.
We'll go in-house. I see a question in the back there. Yes.
Hi, Sophia Bulla from the Foundation for American Innovation. I wanted to return, if we could, for a moment to something Gary mentioned about disclosures being a way to address the critique of over-moderation from platforms. Because I completely agree that it's a way for platforms to empower users to frankly recognize sometimes the ways they're being manipulated by platforms to continue engaging, without forcing platforms to take on this great liability of policing everything that comes onto their site. And I was wondering if you, Gary, or anybody could elaborate on what greater transparency and disclosure would look like for platforms if it doesn't include recognizing the parameters, the major parameters of the algorithm. For example, the Digital Services Act in Europe explicitly calls out users need to be made aware of the major parameters of the algorithm that's promoting the content that they're seeing. And I was wondering how any of you feel about that as a potential transparency measure.
Professor,
well, I want to respond first. So I'll just say, as you're talking, I'm thinking, well, a lot of this is based on print media, and print media has no such requirement at all. And that's, the First Amendment does protect that. So I guess I'd be uncomfortable with that type of very general requirement. But other requirements, such as you identify the people as authentic people, whether you do or not is a good disclosure. That doesn't, to me, impede on something, because there was legislation we fought years ago that basically required that you only could allow authenticized people to comment on anything on the web. And I think we just had a negative. There's reasons people want to be anonymous. I mean, it may be about their sexuality. Maybe they just want honest information. So it made us very uncomfortable. But I think if you just say whether you require it or not is the kind of thing. You could say our algorithms do X, Y, or Z. But I really think this should be a voluntary effort, personally. When you say government says you must do things, I get very uncomfortable.
Right, because then the government's deciding when you're not disclosing enough, and then the government's deciding the contours of what certain very subjective, value-laden terms mean, and that's where you really go down the wrong path.
That's a great question. Professor Goldman has a great article about the First Amendment and transparency requirements. I also wanted to mention that the one that I would support, and I know some of the people in the audience have worked on this, would be disclosing when government tells platforms to take something down or like collaborates with them. And I think that's like a way, shine some light on what platforms and government are doing. And that way I think we're going to get rid of a lot of like over-moderation and job owning.
Yeah. Senator Rubio, before he became Secretary of State, among many other jobs, had a bill on job owning that I thought was actually quite well written.
And there's some in the works right now.
Okay, yeah.
All right, let's go here to this gentleman.
Hello, thank you. My name is Nikolai Cronin. I'm with the RAND Corporation here, along with some of my friends. And so my question is, I have to read off it here. California's Consumer Privacy Act, the CCPA, now requires a cost-benefit risk analysis for using personal information in business. The intent is to ensure that companies do not impose a risk on the public that is greater than the benefits all parties receive. According to the Washington Post, Facebook's ranking algorithm since 2017 favored angry reactions over positive ones. 2019, Facebook's data scientists confirmed that posts with angry reactions disproportionately included misinformation and toxicity. According to the whistleblower Frances Haugen, and I'm probably sure that'll get some reactions here, Facebook turned on emergency controls before the 2020 election, which is good, to quell dangerous misinformation. Good. Afterwards, they reduced those controls to bring back the engagement, and some of that engagement helped facilitate the deadly January 6th riots. This is a clear example of a social media company demonstrating that they can control their algorithm, that their algorithm is designed in part to push anger for engagement, and that their business model relies upon that angry engagement. So my question is, in compliance with the California Consumer Protections Act, Privacy Act, are social media companies ready to demonstrate that the risk they pose to the public is not greater than the benefit we all receive? Thank you.
Well, I mean, first of all, you can't regulate the harm. If you say the harm to society is that bad speech is out there, you're looking down the wrong end of the First Amendment in the first place. So, I don't speak for any of the companies, but I also think if the argument is that California can regulate the algorithm if the algorithm causes quote unquote public harm, it's a non-starter. Lots of speech that causes immense public harm is protected by the Constitution, including the right to distribute it and recommend it. There's books that say you can cure cancer by, waving rocks over your head or whatever. And some people might not get cancer treatment because of that and end up dying. Do we prosecute those people? No. Do we prosecute the bookstores who say this is a bestseller? Of course not. And we can't do it online any more than we can do it, in the bookstore.
I think you proved my point that I made earlier about how when people talk about Section 230, they're actually angry about privacy or some other thing by citing the California Privacy Act and like societal harms that exist just on their own.
I think you both said it well. I mean, I can't speak for Facebook, can't speak to the CCPA. I'll add one thing here, which is users want to understand that the algorithms that are being used are being done in a transparent way and that align with their expectations. And I think we kind of have a responsibility as companies to be transparent about that.
I'm all for, actually, I love the initiatives for, voluntary initiatives being taken to allow users to customize their algorithm. Like, the more control we have over our algorithms, the better we're all going to be. But, you might say that it is not a good thing objectively that Facebook, has an algorithm that prioritizes rage bait or whatever. But just because you might think it's a bad thing doesn't mean it's unlawful in any kind of way. I can sit up here and say things designed to make all of you angry, which I'm pretty sure I've been doing, all I want, and that doesn't mean that I can be sued for it.
You can be sued. You probably win.
Yeah.
I also am not sure what, if this was like a law school hypo, where this leads us, right? So government then decides what algorithms are there to make people angry and what algorithms are there to make people happy. So does government decide what speech makes me happy and what speech makes me angry? Sometimes watching people demolish the Dallas Cowboys online, which is hatred in it, makes me happy. And so I just wonder, what is the result? Yeah,
no Section 230 for you.
This is our year.
It's never your year. It is never your year.
I will say California is a unique state. It's beautiful, and it's full of people that are very optimistic they can make things which will change the world as they view it better. But they also rush the legislation with unintended consequences. And I spent too much of my career fighting legislation in California to ever want to live there.
I'm going to go back online for a question, which is a question which I've near and dear to me to an extent. A question is why aren't private initiatives like crowdsourced content moderation thriving in the way that many liberty advocates would wish they would? For example, there was a study that shows that there's now less people, I think, contributing to things like community notes. So thoughts about decentralized content moderation platforms, and are those not working, or do you think that they are working? But yeah, how do we address this question?
I don't think there's any data to show whether they're definitively not working,
Isn't that what Reddit does? Thumbs up, thumbs down on everything? That's decentralized content moderation.
I disagree with that entirely. Now, people will disagree about how decentralized we are on the spectrum, right? We're not like a Mastodon, right? Yeah. No knock against Mastodon. I think what I would say is the more decentralized that you get, the harder it is for people to get into it who aren't already acquainted with those systems. I love my parents. They're very smart. If I gave them a server on Mastodon, I don't know, I'd have to walk them through it, right?
Probably more than once.
Yes, exactly. So I actually think this is an odd question, because I actually feel like more decentralized platforms are actually getting more credit these
You also
days
don't
than
get
they
as
were in
much,
the last
you don't
few
have
years.
the same access to the data because it's decentralized.
Exactly, and I feel like this is one of the, governments don't recognize this, the difference between how little information decentralized platforms have versus centralized.
Understand something. What are you talking
Yeah, fair. But they don't understand that because we're far more decentralized and because we give it to our users to determine whether something should be upvoted or downvoted, right, or craft their own experience on the platform, they think we have all this information because more centralized platforms have it, and we don't, because that's just not how we work. So yeah, I question the premise.
I also think there is some research done about community notes on X and that Facebook is like launching that actually shows that it is pretty effective. I just saw a community note on the Federal Trade Commission's post this morning, and I thought, wow, that's fun.
But it's also like there is a certain amount of disconnect, and we've seen this time after time in all these fights between what people say they want and what they really want in practice. People might say they want more, decentralization, or they say they want more user-based content moderation, and then they just don't use it when it's there for them. And there's, it's just, people being people about it.
Classic revealed preference.
Parents say they want educational software, then they don't buy it.
Going to go back to the
I miss
audience.
David speaking.
Okay, I'm going to try to do this question over here. Yep. Oh, no. Yep.
Thank you. Janice Wall-Grenadier, founder of judicialpedia.com, which we've had around the world, about 7 million views over that. My question is, in the law that you were talking about in Texas, and I didn't catch if the state law that you were fighting trumped the federal law of the 230, or if you were able to win it with the 230.
So it was HB 20 and Net Choice v. Moody and Paxton were the two cases on Florida and Texas. And technically it's been sent back down, but with a very clear, this law is in the violation of the First Amendment written in the body of the decision.
If I recall correctly, they didn't even get to the 230 question.
Yeah, they didn't. And I believe Steve Del Bianco, in one of his comments to the previous panel, had talked about why they kind of pushed this case to be more about the First Amendment than like do it on the 230 grounds, but it would have won on the 230. Like that federal law trumps state law.
There were multiple layers there. If for some reason it had not fallen on the First Amendment question, it would have been a 230 question, and it clearly was trumped.
Stop putting this energy out into the world.
Why do you guys keep talking about Trump?
I don't need this.
I might have time for one more question. I see a hand in the back there.
Hi, David Sullivan with the Digital Trust and Safety Partnership. We bring together companies, including Reddit, around a framework of practices that is about addressing the practices companies use to deal with these kinds of content risks, not the content itself. My question for the panel is there any appetite on the left or the right in Congress, in the states, elsewhere, to actually look at that kind of content neutral approach to deal with these issues, because it doesn't deal with the things people really care about, which is, I hate this content, I love this content. So is there a way to move that forward, or?
I mean, I think you're doing the way. Fortunately,
Go for it.
You're out there doing the private.
But if you talk to small business owners or the NFIB or other groups that are dealing with what they view sometimes as unfair postings about their businesses, which could destroy. I mean, there's these teenage girls who were going to a coffee shop and something bad happened, and so they got their revenge. They went there every day, and every day they posted horrible reviews and said the coffee tastes terrible. And there was nothing that coffee shop owner, who's a small business, could do about it. And so,
Can't they refuse the service?
well, that's what I said when I heard it. But whatever. The point is businesses are destroyed by people like unhappy on the internet. And the reality is in life, because we all do it, when you get a great experience somewhere, your luggage shows up on time, your plane's there, you don't write a review. You only write a review when you're really upset. And maybe if you have an exceptional experience, you write it. So the internet, just by human nature alone, focuses on bad things, not good things. So I think there's an opportunity there for actually, I think, in the business environment, for small businesses to feel that they have at least a voice, a chance to refute something, which they don't have on a lot of websites.
And one of the reasons why there isn't much stated appetite is because a lot of these legislators are being told by a lot of people who are making very specious arguments that the laws that they are, in fact, trying to get passed are content neutral. So why do we need to do the things that don't touch the content? We can do somehow content neutral, content targeting laws. It doesn't make sense if you think about it, but that's what they're being fed. And so they don't see the need to do this thing that they view as less effective because it involves voluntary cooperation.
Well, on that note, I'm going to close our panel. We will now take a short break. Well, first, give a hands up for our panelists.
And the moderator.
We're now going to take a short break. You can join us back here at 2:35 for our next discussion, which will be on the future of Section 230. Amazing how that works, past, present, future. And we're going to talk about the emerging content moderation strategies, NAI, which will be moderated by my colleague Jennifer Huddleston. So we'll see you all soon. Thanks.
Hello, and welcome back to our final panel of the day here at our Section 230 at 30 event, where we will be focusing on some of the emerging and future questions as it comes to Section 230. For those of you just joining us or tuning back in, my name is Jennifer Huddleston, and I'm a Senior Fellow in Technology Policy here at the Cato Institute. I am very excited about this panel, both for the number of topics that we're going to get into, as well as I feel like many of these are the really exciting and emerging issues that we're seeing more and more debate about, and also very excited about this panel of experts. So to start with, we have Mike Masnick, who is the founder and editor of TechDirt, one of the longest running technology blogs exploring the intersection of technology, innovation, policy, law, civil liberties, and economics since 1998, so only slightly after Section 230 started. The New York Times also once called him something of a Silicon Valley oracle, a title that he takes in stride. And as you may have caught if you were tuned into our last panel, he is also known for coining the term the Streisand effect, a term that describes how attempts to suppress information online often backfire and instead draw far more attention to it. Next, I'm joined by Jess Myers, who is now an assistant professor of law at the University of Akron School of Law. A lawyer and a technologist, Jess focuses on the intersection of law and technology with recent research and scholarship centered on generative AI. Jess is recognized as an expert in U.S. online intermediary liability law and has written extensively, spoken and taught on subjects including online speech and Section 230, content moderation, intellectual property, and cybercrime. And if she won't mind me for mentioning it, she's also often known as the girl with the Section 230 tattoo. Next, I'm joined by Matt Perrault, who is the head of artificial intelligence policy at Andreessen Horowitz, where he oversees the firm's policy strategy on AI and helps portfolio companies navigate the AI policy landscape. Before joining A16Z, Matt served as the director of the Center on Technology Policy at the University of North Carolina, Chapel Hill, and was a professor at UNC School of Information and Library Science and a consultant on technology policy at Open Water Strategies. And then finally, I'm joined by Matt Reeder, who is a seasoned legal and business leader with over 15 years of experience driving operational and regulatory strategy in high-growth environments. He is currently the head of legal at Blue Sky, where he discusses the technical and social challenges of making true platform portability a reality. Before joining Blue Sky, Reeder built a diverse legal career spanning private practice, corporate roles, and consulting across technology and platform businesses. So I'm very excited to focus on what will primarily be two of the emerging topics. That's the question that I think came up a bit for those of you that were tuned in our last panel of what some of these alternative content moderation strategies that we're starting to see emerge look like, particularly questions around decentralization and how Section 230 might play out there. And then, of course, it wouldn't be a tech policy panel in 2026 if we didn't end up with a conversation around AI. So I want to kind of start with that first question, and as I mentioned, where the previous panel in some ways left off, and I'm going to turn to Mike first. Mike, you've written a lot on this idea of protocols, not platforms, and this relates a lot to that question around decentralization, user control, what some other content moderation strategies might look like, as opposed to the more familiar, algorithm-driven or top-down driven that we've typically seen. How might Section 230 come into play in the protocols, not platforms world? And for those who are not familiar with that kind of term or framework, what do you mean when you say protocols, not platforms?
Yeah, that could be a really long discussion, so I'm going to try and give the quickest version of it. But so I wrote this paper in 2019 called Protocols, Not Platforms, which was really trying to explore some of the discussion that I think came up a little bit in the last panel even, but the larger discussion that I think has been going through all of this are these questions of who has control, and when you're talking about speech, who has control of the speech, and was trying to imagine, is there a better way than thinking only in the form of large, centralized institutions having control over where and how people can speak? And so one of the angles of that was, could we decentralize the speech and decentralize the control and decentralize the power, push it out to the users themselves, give them more power? Out of that came some interesting things, including Blue Sky to some extent. So Matt here owes me his job. But the idea was, can we build a better system rather than sticking to the way we've been thinking about it before? The connection to 230 is that is effectively impossible unless we have something 230 or 230-like to allow for that. There are differences, but as some of the earlier panels noted, even in situations where the First Amendment might protect, those are situations where large companies with buildings full of lawyers and lots of money in the bank account, they can handle First Amendment lawsuits and the expenses that are associated with them. As you start to decentralize things, one, you have smaller companies involved, but you also have individuals who are able to do things. And if they are taking on liability for speech that they are hosting or publishing related activities that they are engaging in, that becomes effectively impossible if they're facing ruinous liability for anything that they do. So none of this stuff works without a Section 230 or a Section 230-like situation. And the arguments that people make about, oh, there are bad or problematic content online, and therefore we need to get rid of Section 230, as I think was hinted at in some of the earlier discussions, really what that does is it locks in those bigger players. Without a Section 230, it's very difficult. I don't want to jump on, Matt may have a different take, but it's very difficult for an operation like Blue Sky to operate in the way that I think is very important. I should disclose, because it hasn't been mentioned, I am connected to Blue Sky in that I am on the board. So I don't want to be accused of not disclosing that simple fact. So consider me as biased as you want. But we need things like that, because if we believe in a system that empowers the users more than a centralized company, that becomes effectively impossible without a 230.
So I do want to turn to you next, Matt. And Blue Sky is a newer online platform. Some of our audience might not be as familiar with what Blue Sky even is. I feel a bit bad because I've been reading, or someone's been reading on the panels all day about how those tuned in online can submit their questions via the event's webpage, Facebook, YouTube, or on X. And I feel like we should have added Blue Sky and read it as some sort of question submission, given that you are on our panel and that Billy was on the previous panel. But for those who are not familiar with Blue Sky, could you tell us a bit about the platform, how it works, to some of Mike's point, what makes this style of content moderation different, and what impact does Section 230 have on a new emerging platform with a newer content moderation style?
Thanks. Yeah, Mike covered a lot of it, and I'll sort of repeat it, but I can do the Blue Sky for Dummies version or Protocols for Dummies version, because I find myself in the unique position of having one foot on the dry ground of law and policy as a lawyer, and then one foot on the boat of trying to operationalize these things inside of this company that's growing really fast. So I have to always boil it down. And I like to think in analogies, and one that I think works well here is if we think about the large incumbent social media companies like grocery stores, right? This is a place where you go, the store chooses what's on the shelves, how the shelves are laid out, what the lighting looks like, where the cash registers are, and they have all of your purchase history data. Blue Sky is building not just a platform, but a protocol, and we are much more like the farmer's market. We have some basic rules that say where you can put your stalls and where the aisles are, but then the individual farmers can bring whatever it is they grow or have made to the market, and everybody at the market has access to all of those offerings. And in the analogy, the farmer's market is the protocol, And Blue Sky is just one of those stalls at the market. And it is a platform. Most of you, if you think of Blue Sky, you go to the App Store, you download the app, and it is an app, but it rests on top of this protocol. And that's important both for today's conversation about 230 and just understanding the platform more broadly for a number of reasons. First, we give our users the type of power that Mike just described, primarily in the form of allowing them a credible way to exit. So they own their identity, they own their content, and perhaps most importantly, they own their social graph. So the connections that they build on the platform are theirs. And if Blue Sky tomorrow does something that those users don't like, they can pick up and they can leave and go to another platform seamlessly, taking all of their content with them, taking all of their connections with them, and they don't have to start all over. And then when you think from the other end, which is the farmers in my market analogy, these are our developers. One developer alone in front of a computer can program a new app over the course of a weekend or a week and put it on the App Store. And the very first person who downloads that app and joins, especially if they already have a Blue Sky account, will have an experience of that app as if they are sharing it with 42 million other users. So again, this is the farmer showing up for the first time at the farmer's market, having never been there before, but there are already 42 million people walking around the market. So it's really, it gives developers a way to put their best ideas into the world in a way that people can use. And this is one of the ways that 230 is absolutely vital, and Mike already covered this. That one developer cannot afford, all the overhead that goes along with compliance. And then getting more to your question about moderation, we give users control over their experience in both the additive sense of choosing what feeds offer them content and what moderation tools take content away from whatever feeds they choose. We do have default feeds, but any user can toss them out immediately and choose from any one or any number from over 100,000 feeds that users have created. And these feeds range from being very, very simple. Someone puts together a list of accounts and those accounts posts are presented chronologically, to quite complex and algorithmically driven. So users can choose. So we have a pop culture feed. I could delete my existing feeds and only have a pop culture experience of Blue Sky, but maybe I don't want movie spoilers in my feed. So I can also subscribe to a user-created labeler, and there is a movie spoiler labeler on Blue Sky, and then I can filter out all movie spoilers. So now my whole Blue Sky experience is pop culture minus movie spoilers. And again, these are users who are creating these content moderation tools, and in that sense, they are acting like editors. And so these 230 protections are vital for them to be able to do this in a way that gives users more choice.
As someone who's very excited to watch the second half of Bridgerton season, I'm definitely going to be having to be careful on social media to make sure I'm avoiding those spoilers. I want to bring us to the other, as I mentioned, the kind of elephant in the room. It's not a 2026 panel on what's going on in technology without having a conversation around AI. Jess, I'm going to start with you. When we think about Section 230 and AI, how do you think we should think about this question? How will Section 230 interact with AI, and how will it not interact with AI as well?
Yeah, I think we need to set a couple threshold issues first, right? So before we can even get to the Section 230 question, and I think we've been sort of circling around this on the previous panels, Section 230, it gets us to sort of the inevitable First Amendment answer, right? I think one of the first panels they talked about Section 230 is kind of a fast lane. It's something that you use on a motion to dismiss. But what Section 230 is sort of encapsulating, as we've discussed before, is sort of this common law publisher theory that the person who speaks, the person who actually puts the message into the ether is the one who is responsible, right? And that's based in our First Amendment law. So we have to answer the threshold question first with generative AI. Are outputs of generative AI speech? I argue that they are, but there's a school of thought out there that would say no. Sometimes some argue that the outputs are not intentional, or you can't trace them back to a speaker. I think that fundamentally misunderstands what generative AI is, what a generative AI model actually is. And so if you allow me, I'd love to sort of take us on a tour through how these models are actually developed. There's a really good book, by the way. It's called Automation is a Myth. I think it's an important one to bring up here because as we've been hearing about discussions about algorithms, now generative AI, one of the things that the book talks about is that, look, throughout time, humans have always been an intentional part of our processes. It's just that the process of automation allows the human to become a little bit more obfuscated into the shadows. But they're still there, right? And so let's look at generative AI. Before you even begin to build a model, developers get together in a room and they decide, what is our model going to do? And that's a really loaded question. What do we want our model to specialize for example? Do we want mental health and therapy chatbot? Do we want more of sort of a general chatbot, like as many of you in this room are familiar with, ChatGPT, right? But the question starts, the initial premise is, what is the problem we're trying to solve and what kinds of answers do we want our chatbot to be able to answer, right? Going from there, we have this phase called pre-training. And this is where I think a lot of folks get the generative AI development cycle wrong. How many of you have heard generative AI just trains on all internet data, right? It just trains across the internet, right? So that's kind of true, but not really, right? You could theoretically have a model that just takes whatever Common Crawl, the site that does a lot of this internet scraping, right, and compiles those databases. You could have a model that just only trains on that and that's it, right? It wouldn't be a very good model, right? And that's not really how a lot of these mainstream or foundational models like OpenAI's ChatGPT actually work. What actually happens just in the database curation process is a lot of really hard decisions, right? If you want your model to have sort of a source of truth on climate change, for example, you are going to be very intentional and particular about what data sets you're going to include in that system. And that turns out to be a really hard question and a really political question and a really biased question. What do we think to be the source of truth on climate change? What do we think to be the source of truth on mental health or on, yeah, I'll leave it at that. Like mental health or some of our more trickier questions that kind of come up in the social media content moderation space, right? So it starts there. It's actually highly unlikely that these models just sort of take this big database of all the stuff on the internet and train just on that. And then it gets even more granular than that, right? You might want your model to be the expert on climate change. And so you actually make these really intentional decisions in the training process where you split up your database so that your model remembers or understands specific truths that you want that model to understand. And again, those are intentional decisions that have to happen just at the dataset curation portion alone. And then you schedule the training. And it's a lot like how professors put their curriculum together for students or their syllabus together, right? You schedule, I want my model to learn X at this time, and I want it to learn Y later on down the process, and that actually influences the output. That's just the pre-training phase. But you can see we've had a lot of human intentional decisions that go into that process, right? Moving fast forward, you want your model to specialize in something, you fine-tune it. And that can consist of creating a bunch of specific instructions that are usually handwritten by developers or outsourced to third parties that say, if you get this kind of question, this is the kind of answer I want you to give. And that gets really granular and intentional as well, right? So there's a lot of these intentional points, development points in the model, where when you then look at the output, to say that this doesn't come from, this output is unintentional, or it's magical, or it doesn't tie back to a speaker, is kind of nonsense when you trace it all the way back through the development process. So I start with the threshold issue. Does the First Amendment apply to outputs? I say yes. And in fact, I go even further to say a model is much like a publication. It's much like a book, much like a movie, right? It is the output or the product of intentional editorial decision making. Now to get to your actual question, what does that mean for Section 230, right? And Matt and I have gone back and forth on this. And I'll tee it up and maybe you can kind of come in and we can go back and forth on it, right?
Great.
So this question, and you heard it today, I mean, how are we supposed to come into this after Senator Ron Wyden, the author of Section 230 himself, got on here and said, I have been very clear that Section 230 doesn't apply to generative AI. I appreciate Senator Wyden, and I very much appreciate Section 230, but I think that the answer is a little bit more complicated, and importantly so, right? So we just talked about all of these different inputs into the generative AI system. When you ask me, does Section 230 apply to generative AI, I have a million follow-up questions, right? What's the harm, right? And where in the development process can we say that that harm derived from, right? What if we say, for example, What if we say that the harm derives from third-party content that was found in a third-party data set that the model trained on? Seems logical to me that Section 230 probably applies in that case if we can make that argument. And the things that I worry about when it comes to sort of splitting this generalization of does Section 230 apply to generative AI or not, I think we're going to have to get, if the answer to that is no, categorically, I think we're going to have to get pretty comfortable with arguing that Section 230 doesn't apply to many of the editorial activities that these modern websites do in the same way that generative AI developers do. I think we're going to have to get comfortable with saying, okay, fine, then ranking and sorting content, which is what generative AI does, third-party content, is not protected by Section 230. You can imagine what that means for Google search, right? Curating a third-party database or taking and selecting content from a third-party database is not protected by Section 230. But generative AI does that, right? Editing content. Section 230 applies when you edit and you don't change the underlying meaning of the content. Generative AI can do that. Your Grammarly tools do that, right? Those are classically protected activities, are classically protected by Section 230. But if we just arrive at this blanket case that Section 230 doesn't apply to generative AI, then I think all of those activities start to fall out the window.
You know, as a moderator, I try and play a good traffic cop here, and I'm going to turn to Matt in just a second. But before I do, I'm going to do a shameless plug for some of my own work. I have an article in Liberty University Law Review called "Is AI a Horse or a Zebra?" exploring the First Amendment applications in the AI context. And as Ash so graciously referenced on the last panel, I have a new article that's actually available in the lobby for those of you here, out in GMU's Law Review on on Section 230 and algorithms, particularly after the TikTok v. Anderson case. So if you're curious on my thoughts when I'm not playing moderator on some of the topics, those are where to look. But Matt, I want to turn to you. Jess kind of alluded to this. You're very positive on AI, and I want to start with that. I don't want this to come across as, you know, you're up here about to be an AI doomer in any way, but you have been a bit skeptical of how Section 230 might apply to AI. But at the same time, you're very positive not only on AI, but on AI's potential for speech and for furthering expression. Anything that Jess said that you want to respond to, but also, how do innovators and investors think about the impact of Section 230 or on AI more general on these questions of free expression and user-generated content as we enter this AI era?
Thanks, and it's an honor to be here in this beautiful auditorium. These lights are brighter than I think I've ever been on, brighter than any lights of any stage I've been on, much more glamorous than my typical work location in my backyard in North Carolina. It's also wonderful to be on this extraordinary panel. As Jess was alluding to, we've gone back and forth in a way that's been really helpful for me on this topic. I've learned a lot from her. Mike is a celebrity, as I think many people know in this field. I was walking through New York a couple years ago and was walking through a park and saw Mike and a friend or a colleague at a table, and I went up to him and I said, "Are you Mike Masnick?" I was actually, and this was actually true, I was reading a post that he had published like over the course of the last week on the flight up to New York, and it had like unlocked my understanding of, I think, a child safety issue. And as I was, Mike said, "Yes, I'm Mike Masnick." We talked for a couple minutes, and as I was walking away, I heard his colleague say, "Does that happen to you all the time?" And in this world, yes, I would have been less excited if I had bumped into LeBron.
It doesn't happen very often at all.
Except yesterday.
So this debate, which is sort of a fake debate that Jess and I engaged in a couple years ago, because I think we both ultimately eventually come to the same place, was motivated by seeing in the definitional components of Section 230 the definition of information content provider. And you're an information content provider if you create or develop content in whole or in part, which means like the lower bound of that standard is, did you develop content in part? And my thought was there will be lots of generative AI use cases where you'll at least meet that standard. I think Jess's piece was very helpful in coming in with a lot more technical sophistication and saying, I think the title of my piece was, and this was as an academic before I joined Andreessen Horowitz, but the title of my piece was something like Section 230 won't protect ChatGPT. And that's, I think, too monolithic, and her piece, I think, makes very helpful arguments about why that's the case. But my thought at the time, and I think still continues to be, that for Jess to be in order to be in a world where we can really take comfort about the liability regime that we have that governs AI, Jess has to be right 100% of the time. And that's a very hard hurdle. If even some judges think Section 230 doesn't protect generative AI, we're in a world where potentially there's punitive liability for generative AI. And that, I think, is really challenging for how we think about things in our current role. In our view, we are in conversations all the time where people will say, don't worry about this particular issue. It's just frontier AI companies, not the little guys. And what we say is, we want to be building at the frontier. We want to be investing in the founders and entrepreneurs who are building at the frontier, and that means that they can enter the market. If there's crippling liability, it will be really challenging for them. The current zeitgeist around Section 230, except maybe for rooms like these, sends a signal that I think is a really unfortunate one, which is that Section 230 is a zero liability regime. And I think that's really unfortunate because it is such an elegant balance, maybe not a perfect balance, but an elegant balance for how we think about liability. We want there to be cases, I think, where perpetrators are held liable. We don't want zero liability. At the other time, there are all these other use cases, and particularly when, as I think people on some of the opening panels described really well, the underlying motivation is really to protect speech, where we want to make sure that that speech is protected and there is immunity in certain circumstances. We need that balance, I think, in the generative AI world. One thing that's really important to our firm is ensuring that there's not a zero liability regime. We want perpetrators to be held liable in certain cases, so we don't want a liability shield, or a 100% liability shield. But at the same time, crippling liability that only large companies can afford is going to result in a more concentrated market that's going to result in less speech and is going to be less good for users.
I now, for my next couple of questions, want to turn to the panel as a whole. And as I mentioned in passing, as a reminder, I will, after I finish with my conversation with the panel, turn to the audience, both here in the auditorium. But for our online audience, you can submit your questions via the events webpage, Facebook, YouTube, or on X, and we'll get to those after this conversation. One of the interesting things about Section 230 is how adaptive it is shown to be. I spoke about this a bit in the conversation with Senator Wyden. What we knew of the internet in 1996 was very much different than what we see today, and that's oftentimes been a bit of a criticism laid at Section 230. What do you think we should think about in terms of Section 230's ability to adapt to new applications or new technologies? How is this law able to keep up with the changes we're seeing to technology while still encouraging free expression?
I was going to say, my first reaction to hearing you say that is also that we've also seen that the judicial system has been adaptive to 230. I think Eric sort of referenced this on the first panel this morning about how there have been a series of cases, and that has continued over time, where judges have chipped away bit by bit at 230, weakening almost every aspect of it in lots of ways and sort of taking away a lot of the value of it. And so I think the adaptability goes both ways. And then to get to the conversation about AI, I think, and I think sort of both Jess and Matt got to this a little bit, was that, whether or not 230 applies specifically to AI is almost besides the point. The question is really, can we have a regime that enables AI to exist in a useful way that is also plural, that it's not just driven to a few large companies, which I think most of us agree is problematic. And even, when thinking about decentralized systems, these are not two separate conversations. I actually think they're very much related. The ability, as the other Matt said earlier, for someone over a weekend to create an app on the ad protocol that powers Blue Sky, which I've done literally over a weekend, was because I had an AI tool. I can't program very well at all, personally, but I can use an AI tool to do that and build a system that works on that. If we don't have a system that adapts to these new technologies in a form like 230, in that it prevents liability that leads to concentration and leads to a situation where only the largest providers with buildings full of lawyers can handle the lawsuits, we lose a lot of value across all of these things. And so, I struggle with, I would like it to be 230 and to see that it is actually adaptable to that, because we have some case law and we have some situations where we know that exists. But if it's not 230, we need something else that will adapt to these modern situations. Otherwise, we have a very, very different looking internet, and not in a good way.
Any other thoughts?
I think that's exactly right. And I want to sort of put out there when I was discussing like the different use cases in which generative AI, in which Section 230 could apply to the generative AI underlying activities. I want to be clear, I think that's in the heyday of Section 230, right? Today, if you were to ask me realistically, there's the question of whether Section 230 should apply, and I can give you the law professor doctrinal answer. Is Section 230 going to apply, I think, is a very different and existential question that Mike is talking about here. For every one of those activities that I gave you, curating a database, ranking and ordering speech, aggregating, editing speech, I can list Section 230 cases where the courts have come out completely in what I would consider to be the wrong decision, right? So I think I think realistically, is Section 230 adaptable now as it is? I mean, I don't think so. And if I can go as far as to say, I really think today the spirit of Section 230 is dead. It's a law, it's still on the books, but Section 230, as it was designed, was supposed to give us a guarantee, a federal guarantee to really all developers, all websites, all of us in this room that engage with third-party content. It was supposed to be a sure guarantee that if you were to host third-party content, engage with third-party content, you would be protected by Section 230. And I cannot say today with a straight face that that guarantee exists today. Not based on what we talked about the Anderson case earlier in early panels, not based on where Section 230 is today. So I think, no, I don't think that Section 230 I don't think in its current form, the way that the courts have skewered it and the way that Congress has been inching towards skewering it themselves, I don't think it's adaptable for new technologies. And I think I'm with Mike on, I think we're going to need a regime that is, because as Professor Eric Goldman has published, I think generative AI is doomed if we don't.
Matt, I'm curious from an industry perspective, how are you seeing Section 230 either adapt or fail to adapt, or are there concerns there?
So it feels to me like it is almost by definition has been adaptable. Does that mean it's perfect in the current moment? I don't think so, but like we're having a 30th birthday party for the law.
I'm having a
like
funeral.
there aren't that many law, like one person has it on our panel has it permanently inked on her body. Like the law's been has done pretty well, considering that it was to apply to a new emerging technology. In 1996, there's a lot we didn't know about that technology, and for it to have endured the way it has, I think suggests it is fairly adaptable. I have a lot of admiration and sort of like a FOMO nostalgia thing for the moment when the law was created, because the compromise that was struck just seems elegant, and to be able to foresee into the future the way that the law might be applied and might help to shape the industry, and to reach a bipartisan compromise for that seems so extraordinary in our current political moment. And it feels like it is going to be incredibly, my guess, I think it seems like there's some consensus that we're going to need something here. And in the current political moment, are we going to get something that has like not 100% of the elegance and foresight that Section 230 had, but like 10% of it, 20% of it? Like, yeah, I even think that might be optimistic. And my hope really is that there is some will in the political process to figure out how to do that. I think these issues are unbelievably hard. We're working right now to try to get more granular in how to think about a liability framework for AI. It's incredibly, incredibly complicated, and I think there's an open question that I think there's lots of reason to be skeptical of whether the current political moment can deliver it.
Matt, anything there?
Yeah, I mean, I can add, I think, a very pragmatic perspective, which is to say that the uncertainty by itself can threaten to crush the small players, because the ultimate answer might be right from a policy perspective. The law may hold, but if the plaintiff's bar is going to swoop in and bring class action lawsuits against small and medium-sized companies that want to try to innovate in good faith, then they have a tough choice. They can either do nothing and we can miss out on their good ideas, or they can try something new at incredible risk to their business because they can't afford even the cost of winning those lawsuits.
I am naturally an optimist, but I'm going to take a minute and kind of build on some of Jess's pessimism here for a second, even though it's against my nature. In our last panel, we heard a lot about some of the current challenges that Section 230 is facing, whether it's policies at either a state level or at a federal level that seek to change the law, or whether it's some of the ongoing litigation that we're either seeing the law invoked in or that is adjacent to the law. Our last panel really focused on some of these concerns around potential changes to Section 230, around the potential impact of this litigation. We heard, for example, the Anderson case come up, some of the other cases that we've seen recently at the Supreme Court, whether it's the net choice cases or Google v. Gonzalez and Twitter v. Tamna. What are you thinking of when it comes to our present policy and legal debates, not only for what they mean in this moment and companies in this moment, but what they also mean for the future, for those different content moderation strategies, for those companies that are just starting out, for the developer developing a blue sky protocol, or for things like AI? How might our decisions in these present challenges play into the future?
I mean, obviously it's going to have huge impact. You know, I mean, as Matt was just saying, you know, if there is this risk of liability, you're not going to have a lot of things. And you know, I know we're sort of looking to the future here, but we can look to the past and learn some of these lessons as well. You know, one of the previous panels sort of mentioned in passing the DMCA and the copyright regime, which is a different attempt at creating a sort of safe harbor, but it's much more limited than 230, in that, you know, there's a whole like notice and takedown regime, and if you mess up, then you can face liability. And there are a lot of people who say, oh, you know, 230 should have a similar sort of notice and takedown regime, and then all of this. But in practice, we saw how that worked or didn't work. And there's all sorts of evidence of massive numbers of false takedowns that don't actually violate copyright law, that lead to companies trying to avoid liability, just taking that content down. But even more extreme, you have examples like the Veo case, which I think is really instructive and is sort of forgotten to history. But Veo was a company that was going to be like YouTube. It was hosting user-generated videos. It had tremendous backing from very powerful investors, including Michael Eisner, who was, you know, former CEO and chairman of Disney. And it was supposed to be the company that was going to take on this scrappy little internet startup called YouTube. And they got sued under the DMCA, because the claim was that they, you know, didn't meet the qualifications for the safe harbor. That case went on for a few years. They won. Veo won. But by the time they won, the company had run out of business, would run out of money and gone out of business, and only existed to fight the lawsuit and win. If we are setting up a liability regime that does that, you know, and then we had a decade where the only real, you know, online video hosting platform was effectively YouTube. There are a few sort of smaller competitors, but we sort of ceded that market to one giant company, and everyone then complains, like, well, there's just one giant company, I have too much power. If we don't protect the smaller companies or allow the smaller companies to experiment and compete with a regime that actually protects them in making the choices that they're making, then we end up in that same situation. So we can look to the past to figure out what that future is going to look like. If we don't have a regime that allows for this kind of experimentation, and that's across all of these different areas, the AI area, the decentralized social media, anything else new that is coming along, then we're going to end up in that same thing, where only the really, really incredibly deep-pocketed, you know, single or two players are going to survive. And I don't think that's a very good world.
Matt, I want to turn to you because Blue Sky is one of those smaller but growing companies right now. How are you thinking about some of these present challenges and what they might mean for the future?
When you say present challenges, are you talking AI in particular, or just
any of the kind of particular challenges we're seeing around Section 230 right now, whether it's policy or kind of the potential impact of some of these cases in the courts?
Yeah, I mean, I think we're fortunate right now. I think the state of play with respect to the status quo is relatively stable. Now, again, there are a lot of plaintiffs trying to chip away, and there are some judges who I think are opening the door to some changes, you know, some judge-made changes. But by and large, I think, you know, we are sort of sticking with what's proven and encouraging folks to experiment and really relying on this idea of giving users control. You know, I went back and reviewed 230 the whole of 230. I know today's event is really named after 230C1, but 230C2B is the safe harbor protection for those who provide tools that give users choice. And in one way of looking at it, Blue Sky is such a tool. I think that part of the law is pretty clear, and I think that that's very much in the fabric of who we are, and so how we try to exist in the world.
I think this line of discussion is really important. Like often when we talk about burdens for startups, I think we actually can systematically undervalue them by often looking just narrowly at one component of what those burdens are. So Jess is talking in her opening about a lot of things that I think just make the competitive challenge significant, like no regulatory barriers, no liability risk, data issues, cost of talent. There are immense challenges to saying, okay, this group of people is going to go and start a company, and we're going to compete with Anthropic and OpenAI. Competitively, that's incredibly challenging. We recently wrote a piece about called Greetings from a Garage that was trying to situate founders vis-a-vis regulation from the point of going into a garage to build the next great technology. And the insight that Kevin McKinley, the head of our state policy team, had in thinking about the origins of this piece is that the regulations are cumulative. So often we talk about, like, if we add this one particular law, what's the burden going to be on startups? But they're cumulative. So California is not just, the regulatory burdens there are not just about the transparency law that they passed last year. It's also about their privacy law, CCPA, which is actually, I'm not a privacy person, I hadn't spent much time with it. If you try to channel the energy of I'm going into the garage to build the next great company, it is an exhaustive set of requirements, in addition to their provenance requirements. And there are a whole bunch of laws that end up having cumulative effect. So already it's challenging, and we haven't even gotten to a question of liability. What is the uncertainty around liability? What is the legal risk that you take on? And so I think it's really important to not just think about it in isolation, because it's not in isolation, it's the marginal additional barrier, the additional burden that you're placing on startups who want to build.
Yes. I'd love to add another point to this. And so I think we've been having a really important discussion about what does this mean for the broader ecosystem when it comes to these companies that are starting up. I want to add one more angle to it, and I think it's the speech itself, right? The information access itself. We haven't talked about that yet. Uncertainty in legal regimes breeds self-censorship, right? And just to kind of throw back to some history here, I think when we think about censorship from the government, we think about it in terms of Orwellian censorship, which is you can't say that, right? That's actually not very effective for the government. It's not a very effective censorship strategy, right? Because they're not going to go after each individual person, right, that speaks. What's actually more strategic for governments when we're talking about censorship is self-censorship and creating regimes that ensure self-censorship, right? Mike was talking about how we could look to the past. I agree, and we can also look to the current, right? So I used to do right to be forgotten takedowns for Google, trust and safety. And it was one of the most eye-opening experiences that I had working in that space. Because the way that works, no worries, Google, I'm not going to give it all out, right? But the way that those decisions get made is Google essentially creates these massive flowcharts, right, about a single piece of content. And you have to follow, the moderators have to follow these massive flowcharts to ensure that they are complying with right to be forgotten, right? Right to be forgotten meaning if somebody sends in a takedown request in a regime that it follows right to be forgotten, the service has to go through a bunch of different decisions to decide whether they're going to take that down. And I'm not just talking about copyright, right? A lot of the takedown requests you would see at Google had to do with people who were reported upon. A lot of doctors who engaged in medical malpractice who wanted that information taken off of Google search, right? In the United States, that's something unheard of, right? We would not take that information down, right, unless it's defamatory or illegal otherwise. That's not really the case outside of the United States. And here's the thing, when you have a massive flowchart, right, that you have to follow for each individual request, what do you think is the easier decision for moderators to make when they have a queue of millions of reported content? And when the stakes are so high when they get it wrong, this is the uncertainty, right? Theoretically, these companies have an argument. They could say, oh yeah, this is within the public interest, right? That's one of the limits on right to be forgotten is if the content's in the public interest, then it's protected. But when you have a data privacy authority who's now challenging you over that one piece of content that you decided was in the public interest, what's the easier decision? Pull it down. Go on Google, search, and set your location to the UK. Search anything you want and scroll all the way down to the bottom. You're going to see a message that says several search results have been omitted because of laws in this country. Again, that is unheard of in the United States, and yet that's where we're headed. Because uncertainty breeds that self-censorship. If we don't have a Section 230 in place, then is Blue Sky, how many people are on your legal team? Yeah. So is Blue Sky prepared to have that conversation about each and every individual piece of content, whether it might not be defamatory or not, it might not be negligent publishing or not? Are you going to fight for every single individual user on Blue Sky for every single piece of content? That would be unheard of, and I would not make you want to commit to that today because that would be economically infeasible. So what's the decision going to be? Take the content down. That is the regime we are heading into, and it is a reason why our government is so eager and hell-bent to get rid of Section 230, to enact laws like mandatory age verification laws. That's the information system we're heading into. We don't have to look to the past or the future. We can look right at it outside of the United States. It's coming for us.
I'll just note very quickly, this morning while sitting in the audience, I got a right to be forgotten request from somewhere in Europe about an article appearing on Tech-Dirt. And so suddenly it's like, these things are happening. I'm a very, very small site, but the larger you get, the more of those requests come. And exactly as Jess says, it becomes more and more challenging.
Yeah, and just to add to something Matt said, building on it with Jess's insights, I think that let's call it compliance or regulatory overhead, it's not just cumulative, but it's compounding, right? So especially when you start thinking about some of these safety-focused laws that require data collection, paired with some of the specific data privacy laws, you can increase risk on the privacy front by orders of magnitude when you try to comply with some of the age assurance laws. And unless you can hold them all in your head all at one time, there's incredible risk too, just in how you go about sifting through those things and making the right recommendations to the operators who have to make this stuff work and the software engineers who have to build it out.
And notice how the government at no point has to tell you, take that content down.
Right.
You'll do it for them.
Right.
Not you, Blue Sky.
Yeah.
You're doing a great job.
And I deal with these requests that you described.
Right.
Every day. There's DSARs and right to be forgotten requests, which are incredibly onerous just from a sort of time perspective.
Yep.
And it distracts from our ability to do other things with that same time that might actually move the ball in ways that is really positive for our users.
I know, Jess, you said you thought it was a funeral. I am still optimistic that Section 230 is, in fact, 30, flirty, and thriving. But, imagine we're not here anymore in 2026. We're now at Cato in 2046, and we're at the 50th anniversary of Section 230 instead of the 30th anniversary of Section 230. To each of our panelists, and I'm going to start with Jess because she made that comment, what is the best and worst case scenario in 20 years of where you see Section 230 and its impact on innovation, on users, on the future heading?
Best case scenario, we're having a conversation about Section 230 in 20 years, that it's still relevant today. And I'm sorry to be the downer. Look, I'm the one with the tattoo, okay? This is hard for me. I love Section 230. I love the internet. I am terrified of where things are headed, right? I know I'm supposed to answer your question, but I'm gonna go back to one more point, right, with this whole information loss thing here. Generative AI is where my focus is. I think there was a comment on the last panel about are these companies ready to sort of deal with all this horrible stuff to say that just to ensure that we still have speech online. And I really hope they are, because I really think it's important if we're going to have this conversation about the bad that Section 230 has allegedly brought us or the bad of the internet. We can't have that conversation without the good. And there are a lot of really, really important trade-offs, and I'm going to give you one to sit on. There's been a lot of discussion about generative AI and mental health, right? There's been a lot in the news media about generative AI and chatbots and suicide. There are studies showing today that many of you, I'm sure, have not heard, that are actually showing that generative AI and the internet technology has improved our social baseline on suicide. And that's a huge, huge deal. We have not been there, in the past decades when it comes to suicide, and we're improving that baseline, right? So best case scenario for me is Section 230 is intact. We do, or even better, right? We have a new regime that is maybe a new Section 230 that ensures that we are going to protect the kind of technology that generative AI and that the internet continues to offer us, right? That is best case scenario for me. But I hate to be the doom and gloom here. I don't see our Congress or our government ever giving us that when it comes to generative AI, because I think our current government sees Section 230 as a mistake they never want to make again, right? And so I'm more in the worst, I'm sorry to have the funeral here, but I'm more in the worst case scenario. I'll be surprised if we're having this conversation in 20 years, right? And I'll be surprised if we have more than 3 generative AI companies in 20 years too.
Anyone else? Best and worst case scenario, Matt.
I think it's pretty easy to say, at least in this with this audience, that a revoked Section 230 would be a bad outcome at its 50th anniversary. I think it's a harder question to say, what if it is just exactly as it is, and there's no version of a way to think. There's no new legislation to think about liability in new emerging technologies, or there are 0 amendments to Section 230. I think it's conceivable that would still be a good world. I mean, as we have all talked about, there are enormous benefits to Section 230, but I'm not sure many laws that that govern emerging technologies are intended to just be passed and then not tinkered with in any way. That feels to me, if that is our expectation, that is an incredibly high expectation that seems probably like a little bit unfair to have. My hope would be, there are different ways that people now are trying to think about experimental approaches to public policy. Regulatory sandboxes are one, but there are a variety of different approaches. My hope would be that we could try different liability regimes, and also through different types of product trials, learn something about what the costs and benefits are. I think Jess's point about mental health is compelling. It seems like it would be helpful to have some tests of mental health-oriented AI tools and to see exactly what the benefits are and exactly what the risks are, and then to use that data to inform future approaches to liability. My hope would be that we would have more of that approach so that we're moving forward in ways that improve upon the status quo and don't either revoke what we have or just intend to keep it exactly as it is.
Mike or Matt, any thoughts on best or worst?
So I would say, first of all, if we're here in 20 years, we look pretty good for all being 20 years. Yeah, I mean, I find this extremely unlikely, but I think a best case scenario is just more clarity and legal certainty. I mean, I think especially over the last few years, the uncertainty has been the real problem because it leads to all of the problems that have been discussed. If you don't have that legal certainty, it's as bad in some ways as having a bad law. Again, if we're going pure dreamland ideal, I would expand 230. I would roll back the FOSTA adjustment to 230, which I think was an unmitigated disaster. We could improve that. We could fix a bunch of things, but then also figure out and have clarity over how it applies to new emerging technologies like AI, because it's that certainty that is a huge part of the benefit of 230. In theory, the fact that you are not liable, you can make these decisions. There's a guy, Dave Wilner, who's been involved, most people know him in some form or another, been involved in sort of trust and safety, content moderation stuff from the earliest days. He was the original content policy person at Facebook way back when, like in the very, very early days. And he has talked about the fact that he got to write Facebook's first content policy and to make a lot of the initial decisions and how they handled it, not as a lawyer, but just some guy they hired off the street effectively because of 230. Because if they didn't have 230, all of those decisions would have had to go through lawyers who are much more expensive than Dave was at the time. He's more expensive now, I think. But you have a very different internet without that certainty, where if you have that uncertainty and the liability risk, everything starts to go through the lawyers, everything becomes more expensive, and you lose all sorts of value. So the ideal situation 20 years from now is that we have a strengthened and a clarified 230. I don't think it's likely at all. I think the chances of that are effectively 0. But if we're talking ideal and I can dream, that's what I'm going for.
Matt?
I think I would echo what everyone else has said. I mean, a perfect future would be one where, yes, there's likely to be change, but definitions and liabilities are tailored to the actual harms rather than our assumptions that the status quo has to persist. And we would foster competition in a way that the little guys can bring their best ideas to put tools in the hands of users who can choose, so that the innovators are competing based on what's best for users rather than competing to own the content and attention of those users to then sell it on for their own benefit.
I'm going to turn to audience Q&A, and while I have our mic runners getting into place in the room, I'm going to kind of paraphrase and combine a couple of the online questions that came in, many of which were about the question of Section 230 and AI. And to kind of combine some of these, to what extent would other liability regimes perhaps come into play in response to some of the concerns we're seeing around AI-generated content? Questions around the questions reference issues like professional liability, if it's in a professionally regulated field, as well as things like copyright or intellectual property.
All those regimes apply. So we repeatedly try to emphasize that the primary initial thrust of AI policy should hopefully be focusing on regulating harmful use. So if you use AI to violate the law, you shouldn't be able to point to AI as an excuse. A lot of AI policy, for some reason, has really focused on development-oriented regimes, so impact assessments, audits, and those sorts of things, which are more burdensome for the two people who go into the garage to try to build the next great technology. I do think just the question about, like, are there existing bodies of law that apply, I think that is accurate. I think it undersells one of the important benefits of Section 230, which is its procedural benefits. So I know a number of people on previous panels have talked about this, but being able to exit litigation earlier so that you do not have to litigate to the end where you might win, but you've spent an enormous amount of time and financial resources to get there. That procedural mechanism in 230 is really important, and so I think that will be important in AI as well. That if we're asking startups to go deep into litigation to defend themselves, whether they ultimately win or not is less important than did they actually have to spend that time defending themselves.
Any other thoughts?
I think I echo that, yeah.
All right, I'm going to go to the room, and if I call on you, please speak into the microphone and announce your name and affiliation. So I see down in the front here.
Hi, Andrew Sachs, Noble Learning, Social Learning Network, Youth Trade Learning and Leadership, and Set of Likes. First of all, happy 30th. How about a birthday instead of a death celebration? Now that we have AI and it's moving so fast, it can enable anybody to program, even Mike, right? Are words now something far more powerful than just speech? When something happens and you build something and it then harms thousands or millions of others, what's the legal ramifications of that?
I mean, I think to Matt's point just now, like, you can look at the use and how these things are being used and look to that, but speech is still speech, right? And so if, you know, it's easy to sort of get into this trap of saying, like, oh, like, you know, as was discussed in some of the earlier panels as well, like, there's harm because of speech. It's still speech, and it's still protected speech. So I worry about starting to go down this path where suddenly we're like, oh, that speech, you know, caused harm. The question always also then has to get to, like, what harm specifically? Because is it harm that is from protected speech? Is it, you know, because people come up with all sorts of things in terms of what they count as harm, whether it's, you know, like being offended. Does that count? Or is it, you know, there are all sorts of other classifications. And I think, you know, when you get to any of these questions, you have to dig in on the details, and you can't just say, well, you know, now it's causing all of these harms without, you know, specifically looking at what specifically is the harm that you're talking about, and then what sort of remedies are you talking about. But I'd be very careful about just saying, like, oh, because AI, it's no longer speech or it's more powerful or whatever. You still have, in most cases, humans in the loop somewhere who are, you know, making decisions about how that speech is used, and you can look at that. But, you know, I still think most of it remains protected, whether it's 230 or just the First Amendment, backstopping it. Speech is still speech.
Yeah,
go ahead.
I would just add, I mean, we protect speech because it's so powerful. Yeah. And we don't protect all speech, as Mike just referred to. So if it's unprotected, it's unprotected, and if it is, it is. And you know, I think speech is an incredible thing, and it's not, we shouldn't avoid protection or deny protection because of its power. It's the power of speech that makes it something worth protecting.
Thank you for the question. It's a really good one. And I think just to add on to what my co-panelists said, I completely agree. I think one of the really exciting aspects of generative AI particularly, and just the fact that we're automating speech in general, is I think it's actually revealing a lot of difficult human problems that we're being faced to confront. Sorry to bring it back to the mental health space, but I think the mental health question is a really important one that's coming up with generative AI. There's sort of this causation element that I think Mike was talking about with regards to the harm. And I think where we're stopping in that question is the wrong place to stop. The question is why are chatbots killing people, right? If we can make it that blunt. I think there's a more interesting question to be asked, and I think this is what the speech is revealing. Why are people in droves turning to chatbots for mental health help? And we know the answers to that question. We've had the answers. Psychiatrists, psychologists have had the answers to these questions for decades. Usually, people will turn to technology when there's something lacking in their community. There's something lacking in their home environment, a loss of identity, a lack of belonging, a fear of being judged, right? Those are things that they're unveiling deep-rot problems that we have had in our society that we have used technology to sort of paper over or to gap fill. But now generative AI is putting it back in our face. And here's the great part about generative AI. It's fast. So now we have plenty of time, Congress, and plenty of money to start solving some of these underlying human problems. And I worry that if the solution is, well, turn off generative AI, well then, have we solved the human problem, or is that going to be the next problem for the next iteration of technology to unveil to us yet again?
I was going to say, what you're doing, if you're focusing on the speech aspect of those problems, is you're making those problems worse. You're getting to a point where you're hiding the problems or you're burying them, rather than targeting the underlying issues and societal issues that lead to that problem in the first place. I think that's a really good point.
Matt, anything to add? I just want to make sure I don't skip you on this.
No, just saying, I mean, the political economy of this, I think, is really depressing. I mean, as Jess was saying, I think Eric was saying it on the opening panel, like there are just so many incentives in favor of takedown, and the constituency in favor of keeping up, or the incentives to keep up, can often be so diminished. And I feel like on the set of issues that you guys are talking about now, it can be just like, it can just be really hard to marshal when you've got some of the events that have happened and there's a political momentum in a particular direction, to try to advocate for the cost of lost future hypothetical benefits versus what people see as short-term costs is just incredibly challenging. And so I think people say, like, we've seen the headlines enough, turn it off. Right. And what they're not seeing is, we were discussing this a little bit earlier, like I think the stats are maybe that there are 150 million people who live in a mental health shortage area currently. Something like 50% plus of people who have a mental health disorder don't have access to treatment, aren't able to get treatment. So when we think about turning it off, we're seeing these use cases that have been concerning that we think we're mitigating, but we're not seeing these potential immense benefits that are lost in the future. And I think that ends up resulting in often in suboptimal political solutions.
And on the social media side of it, there have been all these discussions lately, especially about like mental health and social media, and there have been books, best-selling books that have been written about this and talked about it, and all of these studies, and people have jumped to the conclusion that, there's been, it actually turns out to be fairly slight increases in certain locations, not everywhere, in suicide or depression rates, and therefore it must be because of social media. And then when people actually look into the details, it looks like the story might actually be different, even as people are saying, oh, ban it, this is really dangerous, where there was just a study that came out of Australia and another one that came out of the UK that showed people who use social media a little bit were actually better off than people who didn't use it at all. This is teenagers, was a massive study on this. And there was another study that suggested, like, the problem is like figuring out the causality here is very, very difficult. But there was a study that suggested the causality might be going the other direction, which is that those who are not getting mental health help that they need are turning to social media because they have nowhere else to go. And if the reaction is just ban it, then you're saying you're taking away the tool that people are using to cope. You can say that's not the best tool, but if we're not providing them the actual tools that will help them, and you're just banning the thing that they are turning to that many people have found helpful. And there are plenty of stories out there, if you look, of people who have found help using these tools, social media or AI. If we're just saying ban it, ban it, ban it, and we take it away, we may be leading to even more harm. And I think that is something that we should be very, very concerned about, even as it's very easy to just say, oh, I see this correlation, therefore we have to ban it without addressing the underlying problems. And governments everywhere are very good at doing superficial responses to a problem. Actually understanding the underlying problem and trying to figure out how do we actually improve the societal issues that led to this moment is very difficult. We don't see enough of that. And that would be a better discussion to have rather than do we just ban this particular kind of speech.
Which, by the way, history repeats itself. Sorry, we can talk about this all day, but history repeats itself. To your point about the superficial sort of band-aids, right? In the suicide context, traditional media, there was a fear that reporting on suicide would actually cause more suicides. Turns out that the suicide contagion theory has a lot of problems. And so what actually ended up happening was traditional media developed guidelines among all of that, along the major conglomerates to essentially not report on suicide. And so we lost discussions about suicide. Fast forward now to the social media companies, and we see the same sort of self-censorship. Look to the companies that are in this room and go look at their trust and safety policies on discussions of suicide. You can't have discussions of suicide on most of these companies' platforms, right? And so now we're in generative AI. And now we're having these conversations with generative AI. And we're seeing that it's improving the social baseline. By the way, you all should get QPR trained. I'm QPR trained. It's for free. You should learn how to respond to people in crisis. One of the things they tell you in QPR training, the worst thing that you can do with somebody who's experiencing crisis and sort of on that verge of suicidal thoughts is to not talk to them or to shut down. And that's exactly what the states and the federal government are proposing that generative AI do today, is to throw up the 988 number and to tell the person who's experiencing crisis to stop having conversations. That will kill people. That will kill people, right? So we have a really, really hard lesson that we need to learn from our past treatment of media and information that we could be applying to generative AI today, and I really, really hope we don't get it wrong.
I'm going to turn back to the audience, and on this side, I see a hand right back there. No, back. Thanks. If you could again say your name and who you're with.
Yeah, I'm Farzan Badi. I'm the head of Outreach and Engagement at Digital Trust and Safety Partnership. I have other hats too. But so my question is that when we look at Section 230, we are thinking about like this is something that helped Americans, but it's actually standardized a global access to technology. So service providers were not scared that other countries and users from other countries were using their service. And that it's actually helped with the internet to go global. I was wondering what you see, and this shows also the power of standardization as well as regulation. So because I think Section 230 was one part of the story, but also we standardized the internet and service providers through collaboration, through technical standardization. And then in the end, we managed to not to ban like a mailing protocol in one country and provide it globally. So I was wondering if what the role of standard is in this situation, and can they save us? I know it's a little bit doom and gloom today for you, but.
Yeah, I mean, I think there are a lot of interesting questions packed into that. And I do think it's important to talk about, right, 230 only applies in the US, and we've been talking about it, and obviously we have a global internet. 230 did help guide that global internet, which I do think is really important. You know, other places around the world never quite copied 230. They came up with some forms of intermediary liability protections after 230, so they sort of had 230 as the model. I did a study, I can't remember how many years ago now, looking at changes in investment in internet companies in different locations whenever they changed their intermediary liability situations, where if they made it more protective, more in the direction of 230, you immediately saw venture capital investments in internet startups in that space go up. And if you change the liability regime and made it putting more liability on the companies, you saw the investment go down. There was only one exception, which turned out to be India, where a whole bunch of investment went into this one Twitter clone in India, which had very close ties to the government, that they increased liability, and suddenly that one company got a ton of investment. That company later collapsed in some sort of fraud scandal and nonsense. But 230 really did help define the global internet. And now we're at a point where, for a variety of reasons, you have different regions and countries around the world that are suddenly talking about data sovereignty and different restrictions, and there are all these different laws in different locations. Obviously, the age verification laws have been a big deal, and we're fracturing the internet in very dangerous ways, in very problematic ways that I think those people who believe in the internet, are going to regret deeply. And I think that we lucked out from the fact that 230 effectively sort of reached the world before people started freaking out about these things and realizing this. So I worry a lot about sort of where the internet comes out of all this, especially not just in the 230 debate, but all of these different regional restrictions and they're always framed as safety laws, and what that's going to lead to in terms of how do we basically how does the internet fracture because of this?
Other thoughts?
I tend to be a little skeptical around the standardization question when it comes to content moderation specifically and editorial discretion. Part of that stems from the time that I spent in industry, the time that I spent on many industry calls with many different folks in this room and many different companies in this room. One, it's really, really hard to get companies to agree on what those standards should be. And number two, I don't think we should be there either. I don't really want to be limited to the content moderation standards that Google and Discord come up with, because I don't think online age verification is a good approach in the United States. No offense to Google and Discord, right? So I think the standard, I think Section 230 set a standard in that the standard was if you do content moderation, however you choose to do it, which there's all these different sites that do different content moderation, we don't care. As long as you're not creating the content, you'll be protected. And I thought that was the right approach. Give companies the room to make editorial decisions instead of setting them to some baseline that one or two of these major companies who are in the room who will be doing the standard setting, right? Like, is Blue Sky going to be invited to the table? No offense to Blue Sky. Is Blue Sky going to be in these conversations when we're standard setting the internet? Maybe, maybe not, but they should be, right? So. I see maybe standards make sense depending on data optimization or data privacy, right? Maybe they make sense, but I actually, I think the approach that the Trust and Safety Professional Association, the TSPA, where they sort of provide the tools to trust and safety professionals to go about content moderation in ways that make sense for their service, I actually think that's the right approach, right?
Matt, any thoughts on standards?
I think that covered it.
All right, I think we have time for at least one more question in the room. Anyone?
Rob Pecoraro, PC Mag, Fast Company, and other fine publications. Nobody mentioned Grok, so I have to ask that unpleasant question.
Excellent.
Senator Wyden, he got asked about that a month ago on Blue Sky and said, I've long said AI chatbot outputs are not protected by 230 and that it's not a close call. Bad cases, bad law, etc. But if you have a case where this chatbot, in addition to sometimes impersonating Hitler, apparently produces near CSAM, does 230, is it already not exempt under 230? How do you handle that?
The Hitler content or the CSAM, right? Okay. All right. We go either way, right? So just to make it really clear, right? So Section 230, federal criminal law is exempt from Section 230, right? So when we're talking about child sexual abuse material, and I'm not the expert on this to be speaking to this, but we're talking about child sexual abuse material. There's a lot of really important questions that we have to ask before we even get to, is it child sexual abuse material? But that's not a use case that Section 230 would protect anyways. And so in that situation for Grok, right, like anything that would be, Grok could be, or X could be prosecuted for violating federal criminal law. Section 230 wouldn't apply in that regard. I think taking it outside of the CSAM context, going back to Senator Wyden's comments about outputs, right? Again, I think it really depends. How do we get to the output in the first place? I took you guys through a tour of how generative AI is developed, but one thing we didn't talk about was what's the role of the user. Kathy Gellis actually has a really good article on TechDirt that talks about what happens when the user imbues the model with the speech itself. And so what we're seeing right now in the sort of cybersecurity realm of generative AI is that users are getting really, really good at jailbreaking these models. To a point where the user is sort of imbuing these models or training these models on information that the model otherwise would not produce. I think there's an interesting Section 230 question there as to, okay, well, when the user is the one that's providing the information, the user's the one that's jailbroken the model, is it the speech of the providers of Grok or any of these generative AI services, right? And when you don't have the case of the user, then I think you have more sort of complicated questions, right? Again, does it derive from a third-party piece of data that was in a data set? Does the output derive from the fine-tuning instructions? And you might think automatically, fine-tuning. X is the one that writes all their fine-tuning instructions, and that might be true for X. There's actually a lot of generative AI companies where they outsource that to third parties. They actually, if you go online, you can do this as a freelancer, right? Like you can create the fine-tuning instructions. You can create them for the companies, right? And soliciting content is something that Section 230 is classically supposed to protect, right? So if we can trace the output back to something that comes directly from a third-party fine-tuning instruction, Section 230 maybe should protect that activity, right? So again, it depends on, we can't say generative AI is not protected by Section 230, because I don't know what that means. We need to pinpoint it to what activity, what output, and where does that output derive from?
Yeah, I mean, I think the classic answer to any, does the law apply to this or that, is always it depends, as Jess said. I think that's true here, and I think like emphasizing so many of these discussions erases the user from the equation. Again, Jess sort of pointed to the user thing, but I think that's really important. So even in the cases with Grok and the situation of undressing people, which is horrific in all sorts of ways, all of those came in response to user prompts. And yet everyone is focused entirely on, is Grok or XAI, or I guess now SpaceX, as they're owned by SpaceX, are they liable for it? And there is a bigger question of if those outputs violate the law, and there are certainly questions about whether or not any of those outputs actually do violate the law. In some cases they might. Then how much of the responsibility should be on the user for prompting them in that way, in a way that, especially in some of the cases that have been described that seem more likely to have violated the law, are they responsible for it in prompting the tool to effectively violate the law in that case? So I think it depends very much on the context kind of question. And I think it's way too easy to jump to the conclusion that we automatically can blame the model just because someone can use it in a dangerous, problematic, or potentially law-breaking manner.
We have time for one more question, and I'm going to turn to our online questions again. And Jess, you've said several times of kind of the past as prologue, and so our last question in some ways goes back to something that I know came up in our first panel of the day and whatnot. It's a question about traceability, and particularly when we're thinking about Section 230's application or non-application to generative AI. This anonymous user asked, is it accurate to consider this perhaps in whether or not there's a traceability element? In other words, is there someone you can point to hold liable other than the generative AI?
I think it's a really important question, and this is where we start to get into the edge cases, right? So again, the Section 230 is all about who's the speaker or the publisher of the content, right? In most cases, from my research into the computer science literature, most outputs, there is somewhere we can trace it back to. In fact, we just have new research that shows that even with quote unquote hallucinations, and I really hate that term because it reinforces a lot of stigma, and it's an inaccurate technological term, right? Even in cases of hallucination where you can't find where this information came from a fine-tuning instruction, you can't find it, you can't pinpoint it to data, you can't pinpoint it to a prompt, you might actually be able to pinpoint it down to the node cluster where that decision might have taken place, which means you can pinpoint it down to a specific weight, you can pinpoint it down to a specific parameter, and you might even be able to back that up into a decision that a developer made as well. So I think traceability is important. I think the edge case there, like figuring out who's the speaker, right? I think the edge case there is going to be that situation where you have an output and we genuinely cannot figure out, and again, I think this is an edge case, we genuinely cannot figure out where that output came from. I think that's going to pose kind of a harder question when we're talking about who do we point to for liability.
Well, thank you, and I hope you will all take a moment and join me in thanking our panelists for this last panel. As I mentioned, this is our last panel of the day, but it has been a day full of conversations, starting with Section 230's past and how we got here, talking about some of the present challenges, as well as looking ahead to the future. And I think it says a lot about this law that 30 years later, we're still able to have a full-day conference discussing all of these different topics and leave with actually more conversation. I think there are many questions and topics that we didn't get to, and I'm very grateful that many of our speakers have been able to stay today, and I know many of them are also available online in various platforms for those of you who want to engage with them, in part thanks to Section 230, to continue these conversations online. Thank you again to all of our panelists, not just on this final panel, but throughout the day, for joining us, and for our audience, both here in Cato's auditorium as well as online. This will conclude our event for today. For those of you that are here, it wouldn't be a birthday party if there wasn't a reception afterwards, so you can join us outside in the Winter Garden for cupcakes and refreshments. Thank you.